Welcome to the Senate Judiciary Committee. The second to last hearing, unless it's our last. Maybe it should be our last. We have one tomorrow at 2 o'clock. So moved. Well, you want to finish this one first or just go ahead and adjourn? Cowsard's idea? All right. If you want to be heard on a bill, please come and sign up on the sign-up sheets up here. And who wants to kick things off for us? Senator Parent, you feel inspired today? You can decline.
Sure.
What mic number are you?
6.
All right, if you please open us up in a word of prayer.
Absolutely. Dear Lord, please be with all of us as we consider all of this legislation today. Lord, it's getting late in the session, and that's when attention spans and tempers can get shorter, so please be with us and help us do the job that all of our constituents have sent us to do, to thoroughly consider all sides of issues and make the right decisions. And so in your name we pray. Amen.
Thank you for that. All right. We're going to start with House Bill 123. We've already taken public testimony. Come on up, Chairman Werkheiser. Public testimony on this bill. I can tell you since the hearing last week, we have had a lot of work behind the scenes. Chairman has done great work. This is year 3 of working on this bill, trying to make sure that we get it right, and he has been amazing to work with despite his frustrations of 3 years of this, which I would be the same way. And so we have a substitute in front of you, and let's make sure I get the right one because I think we had a new one just a minute ago come in. Is it LC 620206S, or is there a newer one from that?
That's the one, but that doesn't have the
appeal language we got?
Right.
Okay. So
which is pretty simple. Yeah.
Do you want to say anything first? You want me to walk through some of the changes, or how would you like to handle it?
Since you're the lawyer, I'm going to let you walk through it. And
okay. Let's see if I can find where in the bill. I'll tell you that the conversations we had in committee were threefold. And Michael, if you can correct me if anything I say is wrong, especially in the third part. One, we were discussing adding the option for life without parole for a sentencing court, knowing that there may be situations where we know we're not wanting to have the death penalty apply, that's the policy of the bill, but we may have someone that does not need to be let free because they're such a big threat to society. So that language was added, and this is where I think it's line 141. Is that correct?
That's correct.
So that language you'll see, or imprisonment for life without possibility of parole as an option for a sentencing court. The second thing we discussed was the issue of, because we are moving to this pretrial early type hearing where you have the preponderance standard where you're looking at someone's intellectual disability on the front end of a case, there were concerns from the prosecutors about getting notice of the discovery, in particular any experts going to be presented, anything that they're going to have presented at this hearing. There's nothing in the current law we found that really said you had to provide that. And really the hope is that a prosecutor gets information, reviews it, and says, yes, this person is intellectually disabled, we'll consent to it, right? Or if they object to it, we also wanted to add the provision that we talked about afterwards of the defense also getting discovery from the state. And so we have a time period built in where the defense will, or the accused, would give information 60 days prior to a hearing to the state, and then within 30 days of that, the state would turn around and give you information they have. You're looking at a situation, whether it ever happens, we operate in the world of theory, but where you have a dueling expert. So the state may get an expert, they'll have to disclose that to the defense prior to a hearing. That was added. Do y'all have the line number for that?
Lines 22 through 31.
22 through 31.
24 through 37.
Right, 24 through 37. Last point, I believe, was you won't see this in the bill, but we had discussion about how do we, everyone seemed to really like this policy, how do we make this effective sooner? And the opinion from this is where Mr. Walker may have to weigh in if I say this incorrectly. By not addressing the effective date, not putting that in there, it makes it where it would apply to all pending cases. Am I saying that correctly, Mr. Walker?
Thank you, Chairman. Essentially, yes, by not addressing the applicability, it will address, so the effectiveness will be either upon the signature of the governor or it's becoming effective without that signature. But without speaking to applicability, the presumption then is that it would become applicable to any pending case.
So it's applicability versus we're all used to when a bill is signed becoming effective, but this would make it applicable for all pending cases. That's our intent. By removing the July 1st date in the language. Those are did I miss anything?
Yeah, there's one more.
All right.
On line 48.
Yes, it was a cross-reference we had incorrect, I believe, to a code section. Is that?
Yes,
It's not a
well,
substantive.
yes and no, because it also, because there's also, I guess, a policy implication in that. So after, at the end of line 48, where it says code section 5-6-34, remove the period and the quotation mark and put and 5-7-1 period quotation mark.
Yeah, and thank you for bringing that up. As far as changes from the committee, those were the changes. But we also noticed this morning, and some of y'all that practice law will understand this, we're creating a direct appeal right. Meaning that based on the finding of from the trial court early in the stage, this would go straight to an appellate court, to the Court of Appeals or Supreme Court, wherever it's appropriate. I think it would go to Court of Appeals. Is that right?
Supreme Court.
Supreme Court for these because it's capital cases. But the state pointed out, the district attorneys, that code section doesn't apply to them, meaning we had to add another code section where either side has a direct appeal right, because we want to make sure we get this finalized and determined early on in looking at these very sensitive cases. So with that would be a potential amendment we'd ask for the committee to add that code section 5-7-1 at the end of line 48. And Mr. Walker, you may want to weigh in on exactly how that can be worded. I'll call upon you when that time comes up. I believe those are all the changes from the committee. Is there anything else you want to add?
No, I appreciate your diligence and working with me, and like I said, it's been a 3-year road.
So let's see if we can get it done now in the next week. So I appreciate your work on this. Any questions from the committee for the author? All right, what's the pleasure of the committee? Motion to pass from Senator Redd is LC 620206S, a committee substitute. Is there a second? Second from Senator Parent. Does someone want to offer the amendment to add 5-7-1 at the end of line 48? So move, Leader Hatchett. Is there a second? Second from the pro tem. Mr. Walker, do you want to give us that language?
Thank you, Chairman. I would recommend on line 48, after intellectual disability, comma, I would change that language to read pursuant to subsection B of code section 5-6-34 or code section 5-7-1, period.
All right. Does that sound good for those who offer the amendment? So moved, and Pro Tem's on board. All right. All those in favor of the amendment, please say aye. Aye. It is unanimous. Back the underlying motion to pass by committee substitute now as amended. All those in favor, please raise your hand. It is unanimous. Congratulations, and thank you again for all your work, all the advocates, all the work y'all done on this bill. We are almost there now. Am I still allowed to carry it?
Yes.
Okay, I'll be carrying it in the Senate. Thank you.
Thank you very much.
All right, thank you all.
Thank you, committee.
Thank you. All right, let's do House Bill 171. We're going to try to stick on our agenda best we can. Is Representative Thomas here? If not, we will come back. He's here. Okay, come on up. We are working off of LC 560406S. Hopefully I have that right. Is that what you have?
That is the version I have in front of me, and thank you.
Because this is the This is a new substitute versus what passed in the House that we worked on. Is that right? I'm trying to remember if we did a new substitute, if this is the original bill you had.
My understanding is hold on a minute, I can tell you if it's the version that's passed the House. I've got it right here.
Yeah, this is a new sub.
Yeah, this is a new sub.
And
Yeah.
so just for the committee's sake, we heard from Chairman Albers earlier this session, an AI bill. He has worked with now Chairman Thomas on the House side, and I think the plan would be this will be the vehicle for that bill. Chairman Thomas had a very similar bill with a couple differences. I'd especially like for you to highlight the differences between your bill originally and the bill we heard in committee, and also the other changes that were made. So the floor is yours.
My understanding was that probably the major change was on line. Let's see. You have to, like, so you have to forgive me. I'm working on it here. This is the first chance I've had to take a look at this sub, so I'm just making sure I've got all my line items right.
Take your time. There's a lot
Yeah,
flying
as I
around
say,
this
there's
morning.
plenty,
So.
yeah, there's plenty of people waiting. I hate to.
Do you want me to call you back up in a minute? We have plenty
Yeah,
of
you
things
know,
to do.
I
Let's
hate
do
to
that.
ask you that, Mr. But
It's not a problem at all.
it's line 45. Okay. I'll tell you what. To be respectful of my other.
You reminded
members,
me, Senator Harrell, we added your language as a substitute, not as an amendment. Sorry.
So that was what I was looking for.
I could have
which I'm
helped you with
friendly,
that.
friendly to that substitute language.
You want to point out your lines?
It's the lines 46 through 52. Would you like to present your piece of it?
Sure, and I have a parent
Yeah.
who can speak as well. So the author of the bill has generously allowed me to add an amendment, which starts at line 46. Section C. This bill already deals with AI in terms of images that using sexually explicit images of children. So this fits in there really well, in that this has to do with chatbots, which are new, and I have a parent who will speak about it. But these chatbots, from the experience of parents, easily go into sexually explicit material and are marketed to children. So that's what this amendment deals with.
Yeah, and I apologize. In my mind, we were doing a different bill on that. But we discussed that in the last several days, and it's a big issue you pointed out that I think makes the bill a lot better. Is it Katie Fullerton that wanted to speak on the bill? I won't call upon you in just a second, okay? Do you want to present anything else with your bill now that we got that? Sorry, I got my mind's going a million places too.
So it's nothing better than walking in from the parking lot and having your bill called right out of the gate.
Right,
I'm as happy as
right.
can be
You don't
right
sound out
now.
of breath.
So I appreciate the expediency. I think the start at the beginning. I think we're going to give you the abridged version. Right now, as it stands, you can take an AI model and you can train it on the pictures of our children and our grandchildren, and you can now make that model create AI-generated obscene sexual abuse material of that child, of a child or that child. This has now happened in Georgia. For those of you not familiar, Gilmer County had an incident with a Pepsi driver who went into the school, took pictures of the children in that girls in that school, and has created sexually explicit content of those children. That's what this bill aims to address. It aims to also address a couple other small but major things. One of them being defrauding seniors. You can train an AI model to have the likeness and voice characteristics, biometric data of maybe their grandchild. They can call them, and it's to the point now where you could actually have a video phone call of your grandchild, and it would look real to you. That child may have a gun to their head, and with their voice, and hey, if you don't send $10,000 to me right now, we're going to execute, your grandchild. And anybody that sees that is immediately going to say, "Oh, wait a minute, where do I need to send the money to?" Right? Then another piece is aggravated stalking. I mean, think about the terrorism that a poor stalking victim already has to endure, and then we're going to train an AI model, or right now someone can train an AI model and have images of that person being stalked, send that to them. I mean, just to only further perpetuate the terrorism that's happening to these people. So the way this bill is very similar to the bill that you all heard in committee, SB 9. So most of it should be exactly the same. We do have the Harrell, friendly sub amendment. Other than that, I think Mr. Chairman, I'd be happy to take questions.
All right, we have questions in the committee. Senator Parent.
Thank you, Mr. Chairman. Thank you so much, Representative Thomas. I actually wanted to ask you if you could a little bit more specifically tell us what's different versus SB 9.
I think my big understanding is we did 161280.1. And the reason why is 161280 had some constitutional issues that had happened with it. I am not a lawyer. I believe that we have legislative counsel that could probably speak to that a little bit better than I could, if you so choose. But the big thing is that point 1, that was important to make sure that we had this codified correctly. So I think that was pretty much the major change.
Mr. Walker can weigh in on that. Walker.
Thank you, Chairman, and I apologize, I don't have the site available, but the parts of 161280 have been ruled unconstitutional, and throughout the code we refer to this term in that code section. So rather than there being any uncertainty, we just wanted to change the cross-reference so that if 161280 is ever fully repealed or in any way modified, we wouldn't lose all those cross-references to this critical definition.
All right, thank you. Do you have more questions, Senator Parent?
Not right now, Mr. Chairman.
Okay.
Thank you.
Senator Dolezal.
Thank you, Chairman. Good to see you, Representative. Thanks for bringing the bill. I asked the same question of Chairman Albers when he had the bill, and it's relative to the sentence enhancing portion. Mm-hmm. Help me understand the policy position here. It would seem that we're creating this special category of crime. We're actually depicting lewd AI acts with a minor. If I'm understanding this correctly, would have a more extreme sentence potentially than actually doing it in real life. And I don't understand why that would be a policy position that we want to take. And if I'm misunderstanding it, please correct me. I'm looking at lines, starting lines 108, if you're looking for it in the bill.
Lines 108. Oh, sorry, that's the wrong LC.
Why is stalking using AI worse than stalking? Why is creating child porn with AI worse than creating child porn?
Well,
that's really the essence of my question.
I can answer that question. So, the crimes being perpetrated aren't new here. Okay, fraud and stalking has been around for a long time. I call fraud like one of the originals. We got to stop looking at AI necessarily as perpetuating a new crime, but really an enhancement of an existing crime. So for the example of stalking, you have someone who's already dealing with the terrorism that comes along with stalking, but now you have an enhanced tool to be able to create a more believable and vile environment for those individuals. So what it does is it creates an enhancement to the crime that's available to the judge, and I will let the lawyer, Mr. Walker discuss specifically, because we went through quite a bit of this last year, that it adds an enhancement to that crime because it makes sense to enhance the crime because the tool being used is so much more believable. So what it does is it does a two-part where they have to add on this enhancement, and I believe that the way that we've got it set up is that's something that the judge would levy up front. And Mr. Walker, did I explain that correctly? Yeah.
What other crimes are captured? There's a lot of these just general misdemeanor articles and code sections. I actually don't know that I would agree. I could agree with you that perhaps with the exploitation of a disabled adult and some of the things you might do over the phone are more believable with AI. I don't know that stalking actually is. Or there are forms of stalking I could think of where it's not. Let me say it that way.
Well, I think to me it depends on how you define stalking. I think if I got an AI video of me getting being violated some way or another, that has my imagery in it, my biometric data, I think that creates a more believable experience to a stalking victim. It brings a higher level of terror to them, and I think adding some enhancement to it to further dissuade those individuals from using this method is an appropriate measure.
Okay, could you just, and maybe this better, Michael, if you could answer this, what other types of things, are we capturing any sort of creation of child pornography or anything in these other code sections that are referenced on lines 95 through 104? Are these more in the, I'll call it less obscene crimes? That would be pornographic crimes. We'll call it that. Because Representative, I think that what I would say is that my concern would be is that the AI enhancement, even as it relates, certainly as it relates to child pornography, I would argue that the creation of fake child porn is, while awful, less awful than the creation of actual. And I just want to make sure that we're not capturing that here. And I'm also curious on the inclusion of fraudulent election interference. What types of things are that? Maybe you can answer that while Michael looks for the other.
We'll take one question at a time.
Well, I think he's looking for the other one. So on fraudulent election interference, does this get to the whole deep fake thing that has been discussed?
So I guess for the fraudulent election interference piece of it, I'd be more than happy. There's another bill, SB 9, that's kind of incorporated the fraudulent election interference piece of it. If it's the will of the committee to strike that particular line item, because we have another vehicle that's working on that at the moment, I'd be amenable to the amendment.
And Mr. Chairman, I guess we can wait for Michael.
Yeah.
I just want to understand the types of crimes that we're saying.
We can come back to that.
Yeah.
And Michael, just let me know whenever you're ready, if you are ready to weigh in on that. Chairman Tiller, do you have questions still?
I think mine are in line with Chairman Dolezal's of just, I think child pornography is horrible. I think the idea of AI child pornography is horrible as well. Why would we not criminalize them at the same rates? Why is there only a enhancement rather on the AI side? Why would we not just criminalize them both?
Well, I mean, my answer to that is person with. So I'm going to just get a clarification. I'm sorry, Legislative Council. What's the current crime on? Well, you answer your first question, and then we'll go from there. Appreciate it.
Mr. Walker?
Yes, the first point I'd make, Mr. Chairman, is, as I understand it, the sentencing enhancement is not in lieu of sentencing for the underlying offense. So there would be the sentence for the underlying offense, and then this would be an enhancement on top of that. So that just to clarify that, not to comment on the policy decision, just to make that clear that there would be the two elements of that sentencing, the underlying sentencing, and then the enhancement on top of that underlying sentencing.
Can I ask a follow-up on that?
You may.
So essentially we're in a policy question of whether or not AI child pornography should be enhanced in its sentence to a penalty of something more than child pornography generally?
I think that is a policy question, yes, sir.
Okay.
But I think the way to word it would be, if AI is used in committing child pornography, would there be an enhancement in addition to the traditional punishment for child pornography? Does that make sense? Another question from Leader Hatchett.
Not to bring more complexities to this
We welcome
bill,
that.
but 2 years ago, and I went back and referenced this, we passed a bill. It was Senate Bill 466 that was signed into law. It deals with this title specifically, and it deals with violations of this code section and title. In that, it said that it shall not be a defense of a defendant if you were to show that whatever you're charged with was created using AI. So my understanding is, because of that language that was passed, if you have possession or you create and you're charged with possession or creating child pornography, you no longer can use the defense that it was generated by artificial intelligence or a visual medium, so you're just charged with the actual crime itself. Now it looks like we're actually going to make a crime of, and we're going to try to define what child pornography and possession, creation, everything that's in this bill is. And I guess my question is first off, were you aware of that we passed that, and what, if anything, are the distinctions, and was that taken into consideration when this was drafted?
So I have not seen Senate Bill 466. Apparently it was your bill now that I'm looking at it. So I'm imagining I can see why you're
It's
familiar with it.
one of the reasons why I remembered it.
Let me say the committee obviously can do whatever you want, but just so you know, my understanding, you've already voted for this in the Senate. It's already passed the Senate. This is very similar with the exception of the changes that were noted to the bill we already passed that Chairman Albers carried through the committee and also to the Senate floor. Again, we can have second thoughts because things happen fast, but just so you know, this is not a new issue today.
Yeah, so
I didn't expect
I guess
as much time.
You give some background on this. So we did this Senate study committee and the subcommittee in the House for artificial intelligence, and one of the recommendations that legislation was this legislation, which was this is a companion bill that was written for the Senate version of this bill, which was SB 9. So that bill had passed through this committee and it had passed through the House floor with really the most minor change being adding the point 1, which was clarified by legislative counsel. So I just trying to give some context, I guess, to the situation.
My memory, including help with my memory, is that we in committee addressed the bifurcation part. We tried to mirror language similar to the hate crimes law. I think, Mr. Walker, you worked on that. Is that in this draft as well? Okay. I remember that being one of our big things in committee we discussed. Any other questions from the committee? We do have people signed up to speak on the bill. Let's get to our witnesses. Ms. Fullerton, do you want to come up? And
Yep.
Chairman, if you want to sit
Absolutely.
back there.
Thank you, Mr. Chairman.
Thanks for joining us.
Mr. Chairman, Senators, thank you for your time. My name is Katie Fullerton, and I'm here today in support of HB 171 because it will better protect our children from some of the dangers of AI technology, understandably. I'm an AI technologist. I work with companies here in Atlanta to build their AI systems and deploy them in safe and effective ways. And I'm also a mother of 2 children in DeKalb County elementary schools who were negatively impacted by interacting with AI chatbots. In our school, like most schools, kids use Chromebooks to access curriculum and learning apps and all the fun stuff that they get to do. The school subscribes to a program called GoGuardian, which is a content blocking software that is supposed to keep them on educational-only websites, but no content blocking is ever 100% effective or safe. There was an incident at our school where students were able to chat with an AI bot that quickly descended into inappropriate topics for kids, and it wasn't blocked by our security software due to the nature of the website. Services like ChatGPT, which is the primary driver of these chatbots, have developer tools that allow developers to access their large language model for fractions of a penny with no oversight on what comes out the other end or how it's used. There's a financial incentive in this case for developers to perpetuate harm to minors. These model outputs are wrapped in a cheap website that requires no logins, no age verifications, and no security, but does use kids' favorite characters, lots of ads, and they're allowed to turn a quick profit with no restrictions. Unlike a book or TV show, I, as a parent, am not able to preview the content produced by these AI tools due to the nature of AI. I can't determine if what they're seeing is appropriate for my kids. Instead, I'm forced to address age-inappropriate material at the whims of a chatbot powered by a for-profit company. With this legislation, developers and AI companies will be incentivized to implement safety features like age verification tools and programmatic guardrails to prevent these kind of outputs from being generated. that will prevent them from serving this inappropriate content to minors. While AI technology has and will continue to have many benefits for our state, if left unchecked, it will continue to harm our state's children. And as a parent of 2 kids who have been harmed by this, I urge you to vote for HB 171. Thank you.
Thank you. Any questions for the committee? And just so you know, this is lines 46 through 51 is what she in particular was referencing as well in the bill. Any questions from the committee? Thank you. Thank you for your work on this. Next, we have Mac Parnell with Georgia Faith and Freedom Coalition. Welcome back to Judiciary.
Mr. Chairman, I just want to thank Chairman Albers and Chairman Thomas for their hard work on this issue. Thank you for dedicating so much of your time to this important issue. AI is growing. No one really knows what the future of AI is and the potential. We know there's a lot of potential, but unfortunately, there's potential for good and potential for bad. This is a small step forward to send a message and offset some of that negative potential outcomes of AI as it continues to grow. Georgia Faith and Freedom Coalition's support of House Bill 171. Thank you so much, Mr. Chairman.
Thank you. And lastly, Maisie Lynn Girton from Georgia Association of Criminal Defense Lawyers. Hey.
Good morning, Chairman and committee. I'm
Morning.
Maisie Lynn Girton, the Executive Director of the Georgia Association of Criminal Defense Lawyers. We are a somewhere around 1,500, 1,600 voluntary bar of the, well, voluntary criminal defense bar here in Georgia, the largest member-funded group in the country. And we are used to being the underdogs. You see me here as the underdog most of the times I sit at this table. It's a role that I don't mind having. I've had it for my entire legal career. I've always been a defense lawyer, a public defender for all of my time practicing. So it's a label I'll take and I'll wear. What I don't like is the way that this bill makes teenagers underdogs. And I know you've heard me say this with respect to Senate Bill 9. Representative Thomas and Senator Albers have both kindly heard from me about this issue as well, and it's just not getting any traction. And I'm, after the conversation today, even more confused about why not. Because as Senator Dolezal mentioned, there are distinctions between when you're using an actual child to make pictures and distribute them or possess them versus computer images. And in the code right now, in that real life version in 1612-100, you all have carved out some protections for teenagers. You have not carved out any kind of get out of jail free card or free pass to behave badly. In fact, in those situations where a child does harass or embarrass or intimidate or use these images for commercial purposes, they don't get the protections of the carve out. The carve-out that you have in 1612-11 and the one that we are asking you to consider one more time in this AI space would just be protecting kids who behave recklessly because they don't have good impulse control, they don't have good decision-making skills, and potentially on their way between science and math class, a couple of kids decide how funny it would be to put one of their faces on a naked body and send it to their cohort of friends. That's as fast as this stuff happens with these kids. It's quick, they think it's funny. I am with you. I am with Representative Thomas and Senator Albers in being fearful of the descriptions and the situations that he describes and that we know are real. That those adults who are behaving badly, who are going into schools and taking pictures, I am not here to defend that. I would do it if I had to in court, but that's not what this is about. This is about kids. And those of you, I know some of you have teenagers. I know some of you don't. But you yourselves have been teenagers. And none of us had phones back then. None of us were doing these kinds of things. But this is one of the ways kids are going to get wrapped up. And the fact that they are not being handled with equity and parity in this fictitious scenario, when they are being handled as kids in a scenario where real children are involved, the dissonance is just too loud, and I would encourage you to consider leveling it out and getting rid of it by amending this bill. It's got to go back for a degree anyway. I'm not slowing anything down. Please consider these kids. Don't make them underdogs. Let that just be me. I'll take it.
You do have questions, Senator Parent?
Thank you, Mr. Chairman. Thanks, Maiselyn. I wanted to ask you about, I understand your point about the teens, and I believe when we heard SB 9, I did articulate some similar concerns, being a mother of one teenage boy with another one almost there. But in terms of the other issue that we were speaking about earlier, like say it was child pornography, what's your opinion on whether there's this enhancement for AI for a non-real person versus like an image of a real person that was like taken when they were showering or something and then put around the internet? Because I'm still trying to wrap my brain around that part of the bill too.
If I understand your question, so when you look at, let me get the right version. When you look at 560406S, the enhancements are being applied at lines, I believe, 90 through about 105. In that list of crimes and in those articles that are listed, they do not include, well, they do include any misdemeanor or felony offense within Chapter 12 of Title 16. That's on line 104. And I know Mr. Walker's looking at this as well. But 1612-100, the current child porn offense is just that. It's in Chapter 12 of Title 16. So I do believe this enhancement's going to apply. And the sentencing structure in that code section is also a higher and more punitive sentence. So the way it's going to, I believe, apply based on this reading is because it falls into Chapter 12 of Title 16 at line 104, and the offense is a felony, so you jump down to line 115. It's interesting, actually. Oh, goodness. So I'm thinking now that this actually might cause a lenity issue, so I'm surprised you aren't hearing from some of my colleagues that I usually am against in court, because 1612-100 is a sentence of 5 to 25. And it looks here like if the underlying offense is a felony, the imprisonment does jump up to 2 years, so it is an enhancement if that felony started at 1, but the interplay with 1612-100 could be problematic depending on how you perceive that. And I would see if Mr. Walker and I are on the same page if you would, as a committee, like to, but that.
Mr. Walker, do you see lenity issues that she referenced? If you're ready to weigh in on that.
The enhancement would call for a year
in
addition to the minimum sentence, Chairman. So that's how that enhancement would work there. If there was a minimum sentence for the underlying designated offense, then the enhancement would be 1 year above the minimum offense.
Okay, so there's no issue with the rule of lenity on that?
But my question is...
Your mic's still, you're good.
Oh, yeah, thank you. My question is, and I appreciate all that, is it still means there's an enhancement. So there's an enhancement for AI, so you would still get more for an AI image versus like the real kid that's taking a bath.
No, I don't believe so.
Okay, that's what I'm trying to understand. And maybe, I don't know who.
So I guess there's kind of still two questions. So right now, because what Senator Hatchett was saying earlier too, AI is not a defense to possessing with intent to distribute or the other ways that you can violate 1612-100, and that involves the depiction of real children. So if you're convicted of that, the baseline sentence is 5 to 25. The baseline sentence in House Bill 171, when the images are created using AI, is 1 to 15. So you're right now, and the position I think that we would hold, I'm not sure all of your colleagues do, is that if you're involving a real child, it is a more serious behavior, and it's punished more severely because you're going to have a minimum of 5 years. Here, it's a minimum of 1 year. And even in the enhancement context, what it says is that if you're convicted of a felony in any of these listed offenses in lines 90 through 105, if you're convicted of a felony, the court must impose a sentence for a period of not less than 2 years and a fine of not less than $5,000. And if the offense is subject to a minimum sentence of 2 years or more, thank you, I was wrong about that. If it's 2 years or more, so 1612-100 is 2 years or more, it's 5 to 25. The judge has to impose a sentence of not less than the minimum, so 5 plus 1 year. So you're going to jump that to 6 to 25. Thank you. I didn't read that part all the way through.
So that does make it more.
Yes.
For the computer image versus the real child.
I'm sorry. No, I still don't think it's more for the computer image.
Okay.
Leader Hatchett.
Thank you, Mr. Chairman. And thank you for bringing this. I think this is sound policy here because it kind of mirrors the Romeo and Juliet provision in other code sections. The one thing that I wanted to just make sure we were on the same page is if a child appears less than 14, this would not apply. Correct. If we were to adopt your amendment, if it appears to be a 10-year-old.
Right.
This
tracks the language as closely as, like, the ages here are the same ages that are laid out in 1612-100.
Okay.
So yes, if the child depicted did not realistically appear to be at least 14, this carve-out would not apply.
Okay.
Okay.
Yeah. Thank you.
Sorry, I messed up that lenity thing. I just read the wrong part of the enhancement.
If that's the
My
biggest
apologies.
mistake you make today, you're in good shape, right?
Yeah. Thanks.
Any other questions from the committee? We do have another question. Senator Rett.
I think you answered it, but I'm just concerned about young people doing dorky things.
Me too.
You know, I've worked in high school, I've worked with young people in the Air Force, and their mind is not developed. They may not mean any harm. I remember when I was in school one time, and people kept walking past me saying, hee-haw, hee-haw, and I didn't understand why, but then I went in the restroom, I saw my picture on a donkey, you know.
I'm so sorry that happened to you.
Is that what made you a Democrat? Was that too far?
But I'm just concerned. I want to make sure that if kids do, you know, they do silly things, that, you know, we don't handcuff them for life. We punish them, but try and rehabilitate them or push them along the right way.
Thank you. And, you know, and I guess I should underscore, even if this carve-out applies, it's still a misdemeanor. It's still a criminal conviction. Again, it's not a get-out-of-jail-free card. It's just, to your point, a felony conviction has much more desperate impact on a child, or even an adult, but certainly a child. And by child, I mean anyone 17 or under, than a felony would. And that's really all we're asking for. Thank you.
One last thing for me, and we had this discussion before, and you didn't mention Romeo and Juliet. It was Leader Hatchett that did, but we talked about the difference in Romeo and Juliet statute where you really had two young people versus this being one young person doing something. And I think you did present it differently, but it's probably not the best. Do you agree with me? It's not the best comparison when you look at Romeo and Juliet in this situation.
Right, it's not apples to apples. I mean, we have Romeo, and we call it that because that carve-out grew out of some case law that involved young teenagers in a consensual relationship, doing consensual acts together. And so it was easy at the time, and it happened to be a girl and a boy. So we use that nomenclature, but this would not, it doesn't, frankly, that code section doesn't require it be a dating relationship any more than our amendment does.
All right, no other questions from the committee.
Thank you.
Mr. Chairman, close us out and speak on the amendment, if you will.
Yeah, I will. Senator Hatchett, I did want to answer your question on Senate Bill 466. Specifically, it was, I think the big difference is line 15, you use the term identifiable. I mean, that maybe that would be something that, where in this case it may not be an identifiable person, but it's trained off of identifiable people that are our kids and grandkids. First of all, I'm sorry to hear that they did that to you as a child. That's not the nicest thing. I would tell you that
you handled it better than I did, apparently.
I'm sorry they did that to you, like I said. All right, sorry, we're all having a little fun here.
You might need his vote.
Okay, I'll get serious again. But the difference is you went to school, and they did that. When these videos are made, they're put online, and they travel across the United States, and you don't ever get away from it, ever. When you get married, you go to a job, there's a video out there of you performing sexual obscene acts. That's a big difference. Okay, and I understand the position of Gactel, and I can appreciate that position. But I also have to think about the brevity of the person that had this perpetrated against them and the impact that it has on their life. It is significantly more than a couple kids that did something dumb. This is about kids that made pornography, and I'm going to tell you, the kids are dumb. I get it. I was one once too. But I would never have thought that it's okay to make a video of a girl performing obscene acts and think that was funny. Okay, that this is so broadly different, and they're just not even in the same realm of comparison. So again, I've always appreciated the amendment. I don't see how any girl is ever going to say, it's okay to make a porn video of me using AI. I just don't think that's going to happen. Again, but that's a consensual issue, and that's why this whole Romeo and Juliet thing I don't think really applies in this situation. Again, I'm not a lawyer, but I
after we vote on your bill, I don't want anybody to think it's because that comes with some money. Not yet. Not yet. I may have to vote. I don't know yet. So let's wait.
I forgot that rule.
Yeah, don't forget that rule. You have anything else you want to add? We give a question.
No, I would just say that again, this is policy that was created in a joint study committee between the Senate and not joint. I'm sorry, study committee with Senate with us, the subcommittee in the House. We've worked really hard on this legislation. You've seen this legislation before it was voted out of this chamber. And I'm just asking for favorable consideration, and I am very much in support of the amendment. I think that makes what is already a good bill even better. So, I should say the sub with the amendment included from Senator Harrell.
Senator Parent, do you have a question?
Yeah, I was just wondering, so in your example about, I agree, clearly, most people would not consent to have their image, but can it just be some image offline?
I'm sorry, what do you mean?
Well, you were saying like someone, explaining why it's still really bad.
Right.
I believe your example dealt with like a person and whether they would consent.
I would say that, again, that only further supports why I think this legislation is important. What if they got your image offline? They go online and they find 20 images of you. You can train an AI model off of that, and you can pretty much make any video of anybody doing anything that you want them to do. So I don't think that, I guess that's not really a consensual thing. I would never give anybody, just because there's a picture of me out there doesn't necessarily.
Well, no, but what if it was like my face and a porn star's body, which would be easy to generate? And I guess my thought is, if you're like a 16-year-old boy, you might think that was hilarious. And it's not my body, so.
Maybe it is hilarious to you. I don't.
Not
see
to
how
me.
That would
It will
be
hilarious to a 15-year-old boy. Yes, it will be hilarious.
I think if they had it on their own personal device, maybe. But I think if it was started to get disseminated across and distributed, they probably wouldn't be quite as happy about that. Or maybe they would. I don't know. I don't. I've been a long time since I've been a 15-year-old boy, so I don't know. I can't answer that. But.
Yeah, those brains are not very developed.
Thank you. Question? Senator Rhett.
I was going to say at the proper time, I'd like to make a motion to pass.
All right, let's do one more question for the author. Senator Dolezal.
Thank you, Mr. Chairman. Representative Thomas, I want to be fair to you. I'm going to forecast to you that I intend to make a motion to strike Section 3. And I'm going to lay out my logic, and I want to give you the opportunity to reply to it, if that's fair.
Okay.
Let's take the most sensitive subjects off the
Let's
table.
make this easy. But before we do that,
Yep.
let's do it like a motion to pass, and then we can
Sure.
talk about the offer and the amendment. Motion to pass by committee substitute from Senator Rhett. Is there a second?
Second.
Second from Chairman Dolezal. Any amendments, Chairman Dolezal?
Chairman, I would make a motion to amend the bill by removing Section 3 in its totality.
All right. And do we have a second for that amendment? Second from Chairman Tillery. Discussion.
All right, so
Chairman
back to where we
Dolezal.
were. Let's take the example of fraudulent election interference, right?
Okay.
I can create a computer script in 10 minutes using my own brain and writing an SQL script to generate fake ballots. Why should feeding that same request into ChatGPT have a sentence enhancement when the end result is the same?
Is that your first?
That's my question.
So I guess what you're saying, and I'm just want to make sure I understand the context of what it is you're saying. You're saying because you don't like the method that this particular, or that's defined in this part of the bill, Section 3, that you think you should strip it because there's other ways you can perpetrate the same crime?
I am telling you that I think that the methods used to create a crime, if they result in the same crime, the methods used should not result in a prison sentence at one level versus a prison sentence at the other level. And I'm
okay. So, would you agree with the first part of your SQL script that creates a fake ballot? I guess we'd have to talk a little bit more about how does that become a fraudulent election interference if you can create an image of a ballot and keep it on your computer. So, I mean, how are we taking it from there?
I print 15 ballots, I go drop them in a Dropbox. I use AI to print 15 ballots and go drop them in a Dropbox. If I use this, whether I use Grok or I use an SQL script, I would contend that the crime is not deserving of an enhanced sentence because I chose to use a tool that just happened to be different from a very similar tool that I would use otherwise to accomplish the same goal.
I guess, respectfully, Mr. Senator, my answer to that is if you're committing election interference, fraudulent election interference, you should be held to the absolute highest form of whatever that punishment should be.
And that's
I don't
my
think
point.
stripping it.
That's my point.
But I don't think stripping language that further supports what it is that the activity that we're trying to dissuade in any way is a step in the right direction.
Okay, I'm not sure I followed the end of that.
I guess what I'm
we probably
saying
just disagree, and that's fine.
Yeah. Okay.
All right, the pro tem.
Thank you, Mr. Chairman. And I was going to have this question for Chairman Dolezal and you, the sponsor of the bill. And I think maybe there's a little miscommunication. I think Chairman Dolezal is reading this Section 3 as having a singular purpose or a singular result, and that is it's all enhancement of the penalties based upon this type of crime. And so my question is to Chairman Dolezal, if that's your understanding, I'm agreeing with that, but I want to ask the sponsor, is there something in Section 3 that does something different or more than that? And maybe it's where you two guys are not talking on the same wavelength.
Yeah, obviously maybe I don't understand the question. I guess to me the answer is you have certain crimes. Again, these crimes they're not new crimes, okay? Again, stalking, election interference, these things have been around for a long time. AI is a new tool to perpetuate an existing crime. So the idea is because you are now taking something and using a tool to do something that's already illegal, this persuades individuals or dissuades individuals from using this technology because, for one, it actually has more damage. And I can tell you, the people that even spoke today, the damage that occurs from this is increased. So we try to take it, instead of creating a whole new crime about AI, instead what we decided to do is take the existing crimes and just add an enhancement mechanism if this crime was used. And I think that that's the measured approach. Again, this wasn't just my conclusion. The AI study committee in the Senate found the same, had the same conclusion. So thank you. Yeah.
Senator Doles would like. Go ahead.
Two thoughts on that. One, you are creating a new crime exclusive to the use of AI, which I support. So I support your creation of AI-generated pornography being illegal. The internet made it easier to commit some of the crimes that we have listed here. The personal computer, the cell phone, there was a number of pieces of technology that have made it easier to commit fraud. We have, as far as I understand it, never in this General Assembly said if you use this means to create the things that you have identified here, made people subject to a sentence enhancement. And that is, while I support your bill, that is the piece of this bill, and I communicated this to Chairman Albers as well, that I don't understand the policy position of that, because you can run scripts that are just as fast and effective as AI. And so to kind of parcel that out with the sentence enhancement is probably where your and my paths diverge. But I certainly appreciate the first part of your bill.
While we're in discussion, for me, I would oppose the amendment because I think the point you made earlier that with AI, and we have a good example of a situation that Senator Dolezal gave where maybe the prosecutor should not move for an enhanced penalty, because the prosecutor has to serve notice of intent to seek an enhancement. Then the jury has to find beyond a reasonable doubt that AI was used in commission of that crime in order even to get this situation. But you made the point earlier that sometimes with AI, many times with AI, the crime is worse because it's not just the offense that's committed now, but the offense can live on forever. And so that's why, for me, I support the underlying bill, and I would like the bill as it is and would oppose the amendment, though I do agree that there are examples we could give where maybe it doesn't make sense that it should be enhanced. I think that's where, for my opinion, we'd have to trust the prosecutor and how to bring that, and trust the jury and how to deal with that issue. Others want to be heard, though. Chairman Tillery.
Thank you, Mr. Chairman. Representative Thomas, is there a way to draft your bill that we can fix it now where it's not an enhancement, but it does make the artificial intelligence part criminal?
I think that, well, I mean, let's just be honest, we're the General Assembly. We can write bills however we want to write them.
But you don't have it easy.
I think that the thing is, if we hadn't already explored this for 2 years and tried to find, there was much longer versions of this bill a couple years ago, much shorter. We refined it. We've gone through study committees, and through all that process, all the members, be it the House or Senate, come to the conclusion that we felt that this was the best language and the best way to go about it. There's always, we redraft bills, we redraft language in the law, but right now where we're at with this technology, we felt like this was the best approach, and it's a policy decision completely. But I feel like I just feel like this creates such a more believable environment for somebody that this crime is being perpetuated on, that as I would agree, we always are going to have increases in technology. There's always going to be the next bump, but SQL and AI, SQL, you cannot create a video phone call of your face and overlay your face on me and then make a call to somebody as if I'm you. You can't do that with SQL, but you can do it with AI. This technology, it's so incredible, and it can do so much good, and I hate that we spend so much time talking about the nefarious side, but we got to put some basic guardrails up. I feel like this is the best piece of legislation we can do at the moment, and I really do appreciate the question.
All right, no further discussion. Let's vote on the amendment. Everybody remember what they're voting on. All those in favor of the Dolezal amendment, please raise your hand. It is 6, all opposed. It is 3, the amendment carries. Any other amendments? All right, Senator Hatchett. Before you do that, Mr. Walker.
And insofar as this passes, I would need to make several other conforming changes to incorporate Senator Dolezal's amendment if I have the committee's permission to do that.
Okay. Any objection to Mr. Walker making other changes to make this conform to the amendment? Okay, I think we're good. Leader Hatchett.
Thank you, Mr. Chairman. I would like to propose the amendment that was brought to us by the Defense Council, dealing with if a defendant is under the age of 18, that this would be a misdemeanor as long as the child depicted was at least 14 years. I think this is still in order because the section that was just amended is still included.
I believe it would still be in order. You want to offer the amendment as it's written on what was handed to us by Ms. Girton?
Yes, and I think we will have to defer to Ledge Council to make sure it fits, but this is the amendment that I would like to propose.
Let's see if you have a second first. Do we have a second? Second from Senator Rhett. Mr. Walker, as it's written, is the amendment in order as written?
Yes, substantially, Chairman. However, and if I could see clarification, are we just dealing with the Romeo and Juliet portions on the bottom of the page or the entire page, Leader Hatchett? The reason I'm asking the questions, so the first portion that proposes to change subsection D, if that is included in the amendment, unless it is changed, the end result of that would be there would be no penalty provision for Senator Harrell's new criminal offense because the names of those offenses are slightly different. So if this language that's marked on the page that I have in front of me affecting subsection D, which is the penalty section, that the end result would be there would be no penalty for the new offense. So we would have to make a slight change to that. Otherwise, the bottom half of the page with the amendment would apply to subsection B starting on line 37 rather than subsection C. And other than that change, it does appear to be in order. And again, I would ask the committee's permission to make some conforming changes in the title to reflect the new language.
Leader Hatchett, what's your intent? To do exactly what Mr. Walker said.
But also, if needed, I would defer to the author who brought us the amendment.
Ms. Girton, based on what Mr. Walker said, do you understand what's being discussed, and is that what you are offering?
Yes.
You want to come up here to the microphone?
And to clarify, if we were to change the language in the amendment, rather than it being a person commits the offense of distribution of computer-generated obscene material depicting a child, it would read a person who commits an offense under this code section, and that way it would include the original offense that was provided as well as the offense provided in the Harrell amendment or the Harrell substitute.
Yes, and that's the intent. We didn't mean to apply it one way or another. It's just the different versions of these bills have framed that either as a reference to the offense or to the specific offense, and so that's actually why we're on the side of it that it's substantially the same with respect to the penalty, but the language is just different. So I believe it's all finding out. We're not trying to change that code.
Is everybody clear on the amendment being offered? Does anybody need more clarity before we vote?
I would say, how do you prove the age of a computer-generated person? Just putting that out there.
What do you say? How do you prove the age of a computer-generated person?
That's what we have courts for, I guess.
Yeah, I guess.
All right, all those in favor of the amendment, if the author still supports it, raise your hand. It is, well, I got to count. 8, all opposed. 1, amendment carries. Any other amendments? Back to the motion to pass by committee substitute as amended. All those in favor, please raise your hand. Senator Tiller, are you in favor? You are. It's unanimous. Is Senator Albers carrying it?
I believe so, yeah.
Okay, all right.
you.
Thank you.
I just wanted to take a moment to recognize the former Attorney General, Sam Owens.
Good to have you here. Are you in your capacity as former Attorney General or a different capacity? You don't have to answer that. All right. Right. I'm not the Attorney General, but we're going to House Bill 358. Come on up, Representative Smith. Are you sure you want this guy sitting next to you?
It'll be fine.
No, I'm fine with him sitting there.
Oh, okay, good. You got a complimentary laugh from the former Attorney General of your joke. Yeah. All right. House Bill 358. We are working off of the version that passed the House, LC 339770. The floor is yours.
Yes, sir. Thank you, Mr. Chairman and members of the committee. This one-page bill is strictly a clarification of a military installation. It's the 3 lines there. It defines it and goes into the code section with that definition. It's just purely to clear up the code section with a definition.
Did you get a copy of a letter we had from Mr. Weaver with a question about the bill?
No, sir, I hadn't seen that.
He asked whether we should consider the proposed definition of military installation as put on line 10 to be expanded to include facilities owned and operated by the Georgia Department of Defense. I just, as a courtesy to him, he couldn't be here today. It was a question he asked. I don't know if there's anything you want to weigh in on that. Your mic's on if you want to.
Mr. Chairman, I don't think that would be helpful to what we're trying to do. Mine and Chairman Smith's district has a lot of different federal military assets throughout the district, and we just want to clarify.
Keep it narrow and
yes,
what you have. Okay.
For that purpose, and the definition we're using is the exact same definition that's used in the state of Florida and other states that have a large number of federal military facilities in those states.
All right, any questions from the committee? What's the pleasure of the committee? Motion to pass, Senator Rhett. Is there a second? Second from the pro tem. All those in favor of the motion, please raise your hand. It is unanimous. Who's carrying the bill?
Senator Robinson.
Sure. Okay.
Yes, sir.
All right, we're good.
Thank you,
Thank
Mr.
you.
Chairman. Appreciate
Thank
it.
you.
This committee.
Thank you, Representative. We have people coming and going with other committees. So you're staying at the right time, Representative Saines. Come on up. Chairman Saines. House Bill 430. We'll come back to 179 when Chairman Smith is done hearing some House bills. Hold on 1 second, okay? Give me one moment. All right, we are working off of the version that passed the House, LC 481571S. Is that what you have?
Yes, Mr. Chairman.
All right, the floor is yours.
Well, to the learned counsel of this committee, it's a privilege to present to you House Bill 430, which assures the first section, Section 1, simply assures that if you're on the sex offender registry in any other state, when you come to Georgia, you are automatically required to be on the registry in this state. In Section 2, it's been a problem specifically. I won't go where in Georgia, but judges in one county approving a restricted address in another county without, the proper officials in that county, County B, being notified. So that simply outlines that the sheriff and the Superior Court of that B county are notified, and the ability to petition for that address is allowable there as well. That's lines 13 through 28. And that's the bill, Mr. Chairman. Chairman, we also have Shelley with the Sheriff's Association. The Sheriff's Association, of course, helps give technical assistance to all counties that are implementing this registry. So if there's any technical questions, she's available to answer those.
Thank you, Ms. Daniel, and also Mr. Norris, both from the Sheriff's Association here supporting the bill. Anything you want to add?
I'd just like to thank Representative Saines for bringing forward this bill to help us clarify what was the intent originally in the statute, what we believe. So thank you for that and for y'all taking time to hear us today.
All right. No questions from the committee. What's the pleasure of the committee? Motion to pass from Leader Hatch. Is there a second? second from Senator Rhett. All in favor, please raise your hand. It is unanimous. Who's carrying it in the?
Senator Still, if he's still willing.
Senator Still, if he's still on. All right, he's still on. All right, thank you.
Thank you.
Representative Panic, if you want to come up. We are at House Bill 460. Panic, I don't know why I called you Panic.
Don't panic. Don't panic.
Panic.
It's okay.
Panic.
Just panic.
I struggle saying
Right.
your name sometimes.
That's okay.
Panic.
Yeah, just
We
call
were
me
working off the version that passed in the House, LC 481499S. Is that what you have?
Yes.
Floor is yours.
Thank you. This is a simple bill that everyone already thought was law, that no one should be recording communications between a lawyer and their client who is incarcerated. At the moment, they can be recorded, they can be listened to, they just can't be admitted into evidence until, of course, they can be, according to the Georgia Supreme Court. So this provides to stop all recordings of lawyers and their clients unless there's a warrant taken out because they have some belief that there's some type of fraud on behalf of the attorney or their continuation of a crime. That's it.
Any questions for the author? No one signed to speak on the bill. What's the pleasure of the committee? Motion to pass from Senator Parent. Is there a second? Second from Leader Jones. All those in favor, please raise your hand. It is unanimous. Who's carrying it in the Senate?
Senator Cowsert.
Senator Cowsert. All right. Thank you.
Thank you.
You do have a question.
Is this her first bill in front of Judiciary?
Not really.
Not technically, right? Because you're here.
HB 30 was my
kind of important bill.
It wasn't my first. I wasn't number one on that. I was number two, but so maybe technically this is my first as number one. Okay. Am I in trouble?
You could be.
Okay.
You have anything you want to add?
No.
Okay. You picked the right time.
Thank you. Thank you.
Thank you.
Have a good day.
Representative Reeves, you want to come up? House Bill 531. We are working.
Do I need a Senate rules sheet? Just want to make sure.
You want us to give the cell phone number for Chairman Brass? I've just called him several times. I don't think we have a particular sheet. Nothing from us here. We are working off of LC 339825S. A committee substitute. Representative Reeves, I can let Chairman Tillery talk about some of the changes, or also you need to present the underlying bill, which is still in there.
So I'll let Chairman Tillery, do you want to go first?
Sure.
All right.
Thank you. Thank you, Representative Reeves. Thank you, Representative Reeves. All that the only change to the substitute is to add Senate Bill 21, which passed I think it passed this committee. Then I know it passed this committee, and then it passed the Senate floor.
So that's just going to be part 2 of the bill, is that right?
Part 2.
So the rest of the bill should still be the exact same bill that
As you
passed
had.
the House. So if you want to present your bill, then going back to that.
Thank you, Chairman Strickland, members of the Senate Judiciary. This part 1 of the bill, sections 1.1, 1.2, and 1.3. This is the Municipal Sovereign Immunity Act. And what it does is it has $3 million per claim and $5 million per incident, or total per incident. And the way that it got there is the state of Georgia in Title 50 has $1 million and $3 million as the corresponding sovereign immunity waivers for the state. That was enacted in 1992. Counties do not have a corresponding waiver of sovereign immunity. They are arguably at zero liability. Several court opinions over the years, including the Ching versus City of Milton case by the Court of Appeals, determined that on many claims outside of the car accident and car insurance scenario, that cities have infinite liability, large liabilities, and there have been some large liabilities over the years and recently. I was educated by a former member of the General Assembly who's knowledgeable on local government legal issues that there was discussion on this in the past when there was a plane crash on a city airport. So this issue has been around about in the event that cities are determined not to have sovereign immunity, should there be a corresponding sovereign immunity waiver limit like the state has. So the bill was presented in the House, originally in House Bill 132 pertaining to other municipal law issues. There was discussion on that bill, and we postponed the municipal sovereign immunity issue because more discussion was needed. So over the course of several weeks or months this year, House Bill 531 arrived with $3 million and $5 million as the numbers. That was a result of the process in the House Judiciary Committee and the House floor of looking at the numbers. Right now we have infinite liability that cities have that has resulted in some large liabilities. The state has 1 and 3, but those numbers were from 30-something years ago. So that's how 3 and 5 got arrived upon. It was something that honored the civil justice system and compensating people who are injured in cases, but it looked out for the taxpayers, for city budgets. Cities cover these liabilities in a number of ways, unlike the state. The state just cuts a check out of taxpayer money. Cities sometimes buy insurance, sometimes they self-insure, sometimes they have a municipal pool of insurance that way. And so the $3 million and $5 million number was the result of the process in the House of establishing some numbers that could budget and protect the taxpayer while still compensating people who get injured. So that's where that came from. I have heard that Section 2.1 of the bill and the substitute, which hadn't been voted on as part of this, that's proposed by Chairman Tillery, I've heard that is pending in the House in another bill, if I'm correct, in public safety. So I'm not familiar with that provision, but I do understand it's getting heard. Correct me if I'm wrong on that. So, all right. With that, I'm glad to yield for any questions. I know there are a number of people who want to speak on the bill, affected parties, but I would ask you to establish a municipal sovereign immunity amount for the benefit of our cities and ultimately our taxpayers. It would still get victims compensated, but it would not lead to uninsurable and large amounts to the taxpayers.
All right, you do have questions from the committee. Leader, Senator Parent.
Thank you.
Not leader yet.
Thank you, Chairman Strickland. Thanks for being here, Representative Reeves. Question for you. I think I probably know the answer, but I was interested in terms of the limits that we're talking about here in the bill. I was interested to learn that we hadn't raised the states since 1992. Did you have any conversations about that or think about addressing that as part of your legislation?
I know that there are some who may want to update that, but I know that other surrounding states have lower state amounts, and the state of Georgia liability amount and amount in this year's budget is pretty high at 1 and 3. I'm not here to fight the state numbers, but I know that there is much more of an urgency. It's GMA, the city's #1 priority to get some certainty there. The state discussion, it's out there, but that is a separate issue, separate budget, and the state pays taxpayer money, whereas cities are trying to get insurance. So it's a much different analysis, and we focused on this difficult task of getting the cities from where they are now with infinite liability to something that is manageable, that could get victims paid while keeping the taxpayer budget sound. And of course, we have 537 cities now, so there are a lot of them. Some of them are small, some of them are big, a lot of them are in the middle, and this is something that's urgent for them this year. I also neglected to mention it going through the bill, the ante-litem notice. Pretty much every ante-litem notice to governments before suing in Georgia is a year. Cities are 6 months. During discussion in House Judiciary, that Ching case in Milton, there were things that both the plaintiff and the defendant didn't know when that claim was presented in that 6-month fire drill. That they wish they had known when they were talking settlement at the beginning. So we lengthened the ante-litem notice from 6 months to a year so that both the plaintiff and the defendant can examine the claims with more depth like they can for state, county, and many other government entities.
Senator Rhett.
Thanks, Mr. Chairman. I know you probably explained it, but I was reading, but I had a number of phone calls from mayors who prefer 1 million and 3 million.
That is where it started. The House Bill 132, which had other municipal issues, it started at $1 million and $3 million like the state. That's what GMA requested. Also, in this bill, House Bill 531, when we set it out as a separate bill, it started at $1 million and $3 million. In House Judiciary Committee, there was a very articulate move to move it to 3 and 5. That number was not agreeable to the cities. However, the wording of the bill was. The wording you have in sections 1.1, 1.2, and 1.3 in the bill, you did have all affected parties agree to that wording. The committee came up with 3 and 5. I mean, there are a lot of people who are happy with the status quo of unlimited liability. The cities were asking for 1 and 3, so the process presented 3 and 5.
Is this a friendly amendment?
Section 2 is a separate issue from Chairman Tillery, and
He's referring to another amendment I think that Leader Hatchett may offer.
Okay.
I don't know if you've seen that yet.
Okay, I'm sorry.
I've heard about it, but I would rather somebody else present it, and I can respond to that.
Right, we'll give you a
Somebody else can.
copy, but we'll have Leader Hatchett at the appropriate time present that.
Okay.
Is it Senator Still? Whose microphone? Pro Tem.
Mr. Chairman, 2 questions. Representative, the alignment of the 12-month ante-litem notice, would that then apply to all causes of actions against cities or just certain types?
I believe that would apply to all claims against cities.
Okay, good. I think that's a good cleanup measure, and aligning those two, I think, helps practitioners, and you gave a good fact pattern there. In the testimony that was received from the cities about the numbers, they wanted 1.3 and y'all landed at 3.5. Was there any opinions or testimony elicited from the cities or on their behalf that suggested they would have difficulty in getting insurance coverage for those levels? Was that one of the concerns, or was it just liability limits in general, or can you speak to that?
For 3 and 5 or 1 and 3?
Well, this bill would take it to 3 and 5. So I assume since they were opposing that, was one of the reasons, did they suggest, hey, we're not going to be able to get insurance coverage, so there's going to be a gap between that which we can cover and that which we're going to be personally responsible for? I'm just trying to understand there, other than it's a higher number and they want it lower, I get that. Yeah. But are there any functional or operational impediments to the numbers that are in this bill from the city's perspective?
The cities are here, and I think they are prepared to talk about it. I do remember in House Judiciary, Chairman Buddy Deloach, who's familiar with insurance, he asked, has anybody priced all this out? And the problem we have is right now the city's liability is infinity. And so, they can't price it out. So the difference between 1 and 3 versus 3 and 35 million, it's hard to, no, there is no analysis that I know of that gives certainty on that, but certainly the cities are here, and I think they may have some more depth on that.
Okay, great. Thank you. Thank you, Mr. Chairman.
Any other questions for the author? All right, we'll let other people who signed to speak with us. We'll start with Andy Welch, City Attorney for the City of Locust Grove.
Good afternoon, members. My name's Ed.
It's on.
My name's Andy Welch, and I'm sort of soft-spoken. I represent the City of Locust Grove, but I also represent about 8 other cities. As our law firm represents several cities on the south side of Atlanta. And we represent small cities like Woodbury, Molina, Locust Grove, which many of you drive through and just get through the relief of traffic, and you get through Locust Grove and you're like, do I use the bathroom or do I get gas? Or do I stop at Tanger maybe and buy something? But the cities we're talking about are very small cities, and I want you to think about this reality of cities. Our public works director, his name's Jack Rose. He's been in public service. He's about 5'6", but he'll talk you a lot taller. And he wears cowboy boots and he kicks around, and he's been in public service all of his life, from refereeing basketball games to serving in Clayton County and Henry County and and Locust Grove. And he's a common average guy. This is your average ordinary guy, but he's in charge of the entire public works section of Locust Grove, which includes water, sewer, road maintenance, and think for just a second about your average person that's working in these positions. They're not experts at DOT. They're not engineers. They're not, they're certified for water and sewer. They have to be. But beyond that, these aren't chemical engineers. These aren't folks that are, 100% familiar with the Clean Water Act. They're not familiar with every single regulation that the feds push down or that the state pushes down. But in a liability situation, the lawsuit's going to be, well, you didn't follow this particular code. You didn't adhere to exactly this AASHTO standard for the road. You did not comply with the ADA Act. That's how these lawsuits come. And you're asking the taxpayers with this legislation, you could be protecting the taxpayers from increased property taxes and individuals that work for cities from losing their livelihood on salaries that are $60,000 at best. Maybe a director's a little more and a bigger city's a little more. But we're talking about every single city across the state of Georgia. Every small town across the state of Georgia has total liability exposure presently. The caps help. We're talking about generalist and good-hearted Georgians that are doing this work that no one else does, that doesn't make any money. I mean, these are public service work jobs for the good of the people. And they're essential. And while some liability may be appropriate, I would ask that you go to a 1-3 number, not the 3-5. And I want you to think about those cities trying to buy insurance. And Senator Kitty, you asked, is this a problem for cities? Well, most cities are urged to get about $1 million of coverage. They may have 1-3. So that number is not unfamiliar to cities presently. But if my city, Locust Grove, has to go to 3-5, that means we have two choices. We will either shrink our budget, find cuts. We will which means we have to terminate some police officers. We may have to remove some of our public works folks. We may have to reduce staff to make up that number to buy the higher insurance. That's what's going to happen. Or we're going to raise taxes on property taxpayers in the city. And that's how we're going to pay for it. And we're going to have to, the argument is if you don't have any caps, then you got the problem of having to do all of that anyway to cover some kind of lawsuit that exceeds $5, $8, $9, $10 million. So I'm supportive of the measure wholeheartedly, and my city clients are supportive of the measure. But I would strongly ask you to consider the impact of that delta between 3-5 and 1-3. And I think that it's important that when you're looking at the cost spread of this, I think I ran a calculation on it, and it was like you're asking every citizen in my city to pay about $300 to $500 in extra coverage if there's a suit that's brought and we didn't have coverage, if we didn't have any insurance at the 3-5 numbers. So it's a significant amount of money that comes out of the taxpayers' property taxes. They're going to have to cover claims that are $5 million or better. Bigger cities may be able to cover this, but the vast majority of your cities, especially in rural Georgia, are small cities. And that 3-5 number is going to be very expensive to purchase and provide coverage. I mean, I begin to wonder whether or not they should have insurance at all, and then where does that leave victims? There is provisions in the law that says that, look, automobile coverage, the extent of municipal coverage is only to the extent that there is insurance. So if cities don't get insurance, where does that leave citizens that are hurt? There's a policy balance here, and I would ask that you go with 3-5. I appreciate your time. Any questions? I do have a couple of things I wanted to suggest changes if the chairman would allow me to. Because there's a question that was asked by Senator Kennedy that was, does that code section dealing with the waiver provision that's the 12-month rule. So it was on line 21 of the former bill. I don't know what it is on the substitute. But that provision, what was in section 2, lines 21 through 27, that's existing code, and the change was to make it go from six months to 12-month presentment period, which is the same as counties have. Except your question was, does that provision apply to any claims? And the answer is no, it applies to tort claims. And the Supreme Court has ruled on this numerous times that this language, presentment language, only applies to presentment of tort claims.
You'll be section 1-2, which is 22 through 34 in the sub. I believe that's what you're talking about.
Yes, I'm sorry. It's 28 through, lines 28 through 34 in the sub. And so no, the answer to your question, Senator, is that this provides only presentment requirements as to tort claims. And what I would ask you to consider is language that would say, sorry, I'm nervous, is at line 28, after where the word a appears, make that any instead of a, and so it'd be any claim, and I would put whatsoever after claim just to double down, but y'all are better drafters than I am. And then I would also change at line 38, after the word that, I would add the word all and remove the word tort. And then the final change I would ask the committee to consider is on line 45, striking the words under this chapter. And all of that does is, to Senator Kennedy's, to your question earlier, all that does is broaden the requirements that need to be met, that this will apply, that the insurance coverage, whatever you set those numbers at, will apply to all damage claim situations. And then also it will put the presentment requirement the same as what it is for counties at 12 months for any and all claims. So I would ask that you make those changes, but I really appreciate the opportunity to speak, Mr. Chairman, members of the committee. It's good to see your faces again. If you have any questions, I'll be happy to take them.
You do have questions. Pro Tem?
Mr. Chairman, Andy, thanks for being here. So I guess the question is, what now are we looping into that would be governed by a 12-month ante-litem notice that is now different?
Contract claims would be one. If there was an equity claim, which are typically not able to be brought, but in some cases are. You have zoning cases that should be brought. Typically, those are done at the 30-day mark, but that would just ensure that we get that advance notice. And when you think about it from the taxpayer's perspective, which is ultimately who's liable for all of this. So whether it's paying for insurance or it's paying for the claims that result from a tort, from any kind of case, it's the taxpayers that pay for it. It will be siphoned out of their pockets. So what this does is it ensures that the city council gets that first opportunity within a reasonable period of time, a year, as the amendment is, or as the Senate bill substitute is proposed, gives them time to go fix the problem. And I'm always advising my clients, look, let's analyze the problem, let's look at this problem, and then let's go resolve it if there's a reasonable offer on the other side or there's a problem. Let's also say we have a bidding situation, Senator. I'm trying to think of all the scenarios, but these are the big ones. You have a bidding situation, you put out something for bid, and there's an error in the bid process. You need them to present sooner. Why? Because you're about to start construction. I mean, so it needs to be presented in a timely fashion because you're about to do a public works project.
So for the contract claims you're talking about that wouldn't ordinarily be under the ante-litem notice as contemplated here, what is that then? Just a normal applicable statute of limitations period?
That's right. Yeah, and this wouldn't change the statute of limitations other than it would say you need to present the claim within 1 year. So if you've got a claim, present it within 1 year.
Well, it wouldn't change the statute of limitations, but it would inhibit the ability to bring the case right, to bring the claim if timely notice is not given.
That's correct.
So it would be impactful. I'm trying to figure out how much of a difference we're changing the model under which we all operate now, lawyers, cities, counties, if we're going to expand this beyond tort claims and now to be all claims. I'm not saying I disagree with the policy as you're suggesting it, but we may be making a big change here, a little bit on the fly that I'm not sure I've thought through enough that I would want to hear from others on that.
It is the same as what the counties have in the current law. So as a policy choice.
So for the counties, it's for all claims,
all
not
claims.
just torts?
All.
Okay.
Any and all claims.
Okay.
100%. So I was trying to put us in parallel with the county law. So if it's good to protect counties, then why wouldn't it be good to protect your municipalities? That seems logical to me. So
well, me too, as you explain it. I don't disagree with that. I just want to make sure we have an appreciation
and I
of
do
what we
represent
would be
several
doing.
counties. So sorry, I didn't mean to interrupt.
Chairman Tillery.
Thank you. I think I'm tracking with Senator Kennedy here. What about our body spent a long time dealing with mandamus claims a few years ago? Would you have to bring your mandamus claim within 12 months?
That's the way the law is interpreted as it applies to counties. Yes.
So would we end up at the position we were? I don't remember who carried the bill, but I know it was. Do y'all remember it? It might have been you, Senator Kennedy, the one where you can actually bring mandamus against the state or local governments.
Might have been the guy sitting in the chair.
Might have been you. Might have been you. Might have been you. Do we end up at the position that we were at 2 years ago, 3 years ago, where you can't bring an action against your government to enforce the rights that your government's already supposed to be enforcing?
You still can. It's just you have to give them so if I think that you're violating the law, and identify it. Let's say I think that you're adopting a law as a city council that I think is illegal. Then all I have to do is write a letter that says I think that this is illegal.
Right.
Within 1 year.
I get the ante litem, but let's run through that. The tax commissioner's supposed to give refunds. I don't know why they'd give refunds, but use this scenario with me. They don't give refunds. I don't send my letter. In year 2, can I still bring my claim?
Wouldn't apply to tax commissioners. It just applies to the city.
Oh, right. I'm using I was using the government example.
Yeah, and those claims, as I understand it, don't only apply to the county board of commissioners, the county entity itself.
So the mandamus, you can't seek mandamus against the city?
You can.
Okay. And if I don't bring if I don't present that claim within 12 months, can I still bring that mandamus claim?
I think you can once you've if you haven't presented it within the 1 year, then that's right.
That's my only worry. I understand it for tort, supportive of tort. If we leave it at 6, it doesn't bother me at tort. But I worry more about what we're doing on some of the other claims, as the Pro Tem mentioned earlier. Just want to make sure we're careful on that.
Yes, sir. I appreciate that very much. I'm making my pitch.
Yeah.
It's not in the bill, so if you adopt it as it is written, the substitute as it is written, with the 1.3, which is the main point of my presentation, not these small amendments, but with the 1.3 side to it, then the changes I've asked for won't happen. It'll be the standard law as it is. You're just changing it from 6 to 12, which I don't particularly like. But the 1.3 is where I think the numbers need to be on the legislation that is in the substitute, so instead of the 3.5.
Back to the Pro Tem.
Thank you, Mr. Chairman. Just for the benefit of the committee discussion, I appreciate what Mr. Welch is saying, and I think I generally agree with it. The problem is I'm not comfortable knowing what the scope of the impact would be if we change this right now. I'd be happy to look at this at another time, which means next year at this point functionally. But I do like the idea of taking the 6 months to 12 months, so there's alignment there, but leaving it to be applicable to the tort claims. And then I'm certainly willing to look at, the utility of having that ante-litem notice at 12 months apply to all, but I don't feel like I know enough right now of functionally what that would do. But happy to look at it later. And I am interested and hope the committee will, I guess we'll see what the will of the committee is on the 1.3 change from 3.5 back to 1.3. Thank you.
Any other questions from the committee?
Thank you.
Thank you.
Yes, sir.
Next, we have Rusi Patel, General Counsel for Georgia Municipal Association. All right, and also Kurt Ward, the mayor of Brazelton. Thank you for being with us. The floor is yours.
Thank you, Mr. Chairman, members of the committee, Rushi Patel with the Georgia Municipal Association. And I really want to focus on the underlying bill and the numbers. As the author noted, we came to an agreement with the trial attorneys on the language of the bill. We just had a difference in the opinion on the numbers. And as it came out of the House, it came out as $3 million per person, $5 million per occurrence. It was originally $1 million per person, $3 million per occurrence, which is the same level as the state. And we would like to see this committee go back to $1 million, $3 million. When we look at cities in the state of Georgia, we have 537 member cities. Over half of our cities have revenues under $3 million. So what that tells you is their budgets are lower than their revenues, because unlike 48 other states, cities in Georgia cannot declare bankruptcy, which means if we go beyond what we make, what we bring in, then we have no options to restructure our debt. We are having to raise taxes. We are having to cut services. And if we can't even do that, we're going to have to give up our charter, and that debt doesn't go away. That debt becomes the debt of a county. And so when over half of our cities have less than $3 million in revenue, that is a real problem. This is a growing issue for cities in the state of Georgia. So we would really appreciate this committee strongly considering going down from 3.5 to 1.3. When you look at our neighboring states, Alabama is 100,000, 300,000. Tennessee is 300,000, 700,000. South Carolina, 300,000, 600,000. Florida, 200,000, 300,000. And not a neighboring state, but Texas, 250, 500. So every one of our neighboring states is well below what we're even asking for. And this is important for us, is that we could have brought legislation seeking something similar to Florida or Tennessee or anything like that. But we thought parity mattered. And parity matters with what the state has at 1.3. And we think, that's a fair number to pick. And so I know you all have had a long day and you have other bills on the committee. I want to turn it over to Mayor Ward real quick to talk about what's going on in his city.
Yeah, sure. Thank you, Mr. Chairman, members of the committee. Senator Cooney, I'll just try to answer your question on the front end. If I remember correctly, testimony in the House, Judiciary, there was a discussion about, hey, can't you just buy an unlimited amount of insurance, and how that would be a completely defeated philosophy, and even a reference to having to go to Lloyd's of London or something like that. In our city, we have a 1.5 policy in place currently. It costs us around $250,000, a little north of there. And we did some research to figure out, hey, what would that cost us if we took it to a 3.5 situation? And it's either a double or a triple of what that would be. So if you're a city with a $3 million annual budget and you're trying to carry $3 million, $5 million in coverage, you're likely considering something in the nature of $750,000 of insurance coverage alone on a $3 million budget. With regard to Brazelton, if this were to happen to us, the extensive verdicts, if you're looking at those, whether you call it a $5 million verdict, a $10 million verdict, $30 million verdict, of course, is some of the discussion that's out there. A couple of situations would either have to happen. The balancing of the scales would have to happen one way or the other. If it's a $10 million verdict in Brazelton, we're north of a $2 billion tax digest. With a $10 million verdict, that's 13 mills immediately on the property tax that would be added. If you take a $1 billion tax digest, if you take a city with about 5,000 residents, a little over 3 residents per home, take 1,500 homes at about 400,000 each, take a $400 million business tax digest. So you're at 600 million residential tax digest, 400 million business tax digest. You put a $10 million verdict on them. You're looking at 25 mills. You're looking at over $4,000 per home if you're in a $400,000 home. This gives you some economies of scale of how this is going to work. Even with the increase of insurance going up to $3 million, if we add another $500,000 to our general budget, you're taking away. We have a little over 20 police officers on a $2.5 million budget. You're taking away 20% of that public safety budget. You're taking away potentially 10 officers off the street. If you look at it from the perspective of, hey, what are you going to do with water and sewer? How are you going to manage that? We have 20 lift stations we have to gauge every day. We have to do maintenance on those as well. It would be a dramatic impact on us to take not only this difference in insurance coverage, but also if we had to go to the property tax route. We all understand how difficult property taxes have been more recently with the 2010 era, lowering property taxes, and lowering values, and then 2020 raising them. So hopefully that's informative from the Brownston, perspective, and some of the small city perspective as well.
One question, I guess, from a broader standpoint, from GMA standpoint, if the bill is not amended, would you rather have this bill held for another year, or would you still want the caps in the House version if that's where we end up?
I think the challenge that we have is that this is a growing problem for our cities, and we can never tell when litigation is going to impact our city. So this is a big problem, and we would like to see it addressed.
So either way, I know you prefer lowering the caps, but you'd still prefer us vote out the bill as the House version if that's what we have left.
We would very much prefer the lower caps because of our size of our cities. 75% of our cities are less than 5,000 people.
All right. Any other questions from the committee for the mayor or for Mr. Patel? Thank you all. Thank you for being with us. But you do have a question. Okay. Senator Calzert.
Thank you, Mr. Chairman. Mr. Patel, are cities liable for punitive damages?
Yes, I believe so.
Okay. Do they have bankruptcy available as an option if one of these nightmare verdicts were to happen?
No, they do not. There's a state statute that prohibits bankruptcy for cities in Georgia. Iowa is the only other state that has that prohibition.
So how would a plaintiff ever collect their verdict, their judgment, if they got a $10 million judgment, the county had, $500,000 in the bank?
Yeah, so if the city had a large judgment that exceeded their revenues and their rainy day fund, the city would likely have to increase their taxes. They would have to cut services. They would have to find a way to pay that money. They'd probably have to find a way to negotiate the amount with that plaintiff. But we don't have an escape clause or escape hatch of a bankruptcy.
Okay.
Here are questions from the committee. All right, thank you. Do you want to close out, Representative Reeves? It's everyone that's not to speak on the bill. And if you had a chance to look, I know you knew about the one amendment. Did you have a chance to look at the second amendment being offered?
I looked at that insurance matter, and sort of like Andy Lightem noticed, there are some interesting issues in that I'm glad to work with the Senate and affected parties on in the future. However, what I can say is House Bill 531, for weeks, if not months, every word that's in there was carefully reviewed and fly-specced, and it has an equilibrium. So changing the scope of the bill, I think, is going to throw that out of whack. I would ask the Senate to stick to the scope of 531 because these issues about insurance, these issues about the illegal immigration, those are issues that are different from the municipal sovereign immunity issues that we've got. President Pro Tem Kennedy asked a good question. What's the scope of this? This is municipal tort claims. If a city has a fleet of cars and trucks, they have a policy, and so their liability there is governed by that policy. However, for those many unknown tort claims, negligence, nuisance, negligent performance of ministerial act, in the city of Milton case, you had a Yale student who swerved to miss a deer, and he hit a structure that was determined to be a city structure, even though a private party had built it, and it ended up being in the right-of-way over time. So unknown tort claims is the scope of this act. This brings down certainty on those unknown tort claims. Andy Lightem notice, I know in House Bill 155, I believe it is, which is in Senate rules, there was a discussion about Andy Lightem notice and zoning there, and you had 12 or 15 zoning lawyers have 12 or 15 different opinions. So if we stick to Andy Lightem notice for tort claims or sovereign immunity for tort claims, I think we've got the wording worked out. Cities aren't the state. The state has a larger number of claims. They have taxpayer cash that they're cutting checks for. Cities, on the other hand, they have a specific number of services, a specific universe of funds. They have the ability to get insurance to govern those claims, and so cities are different than the state, and this bill reflects that both in the wording and the numbers. The House version, you know, it went through the process and it balanced civil justice and compensation to people like that Yale student versus the need for cities to keep giving their services. Status quo is unlimited right now, so would definitely ask the committee to use the wording, pick the numbers that improve the status quo in a way that you know, is fair to both the taxpayers and people who need compensation. And I present that and yield for any questions.
You do have a question, Leader Gooch?
No question, just ready to make an amendment and move.
All right, what's the pleasure of the committee? Motion to pass by committee substitute. Second. From Leader Gooch, a second from the pro tem. It's time for amendments. You have amendment, Leader Gooch?
Amend line number 34, change the number 3 to a 1, and then on line 36, strike through the number 5, replace with the 3.
Before you do that, make sure you look at LC 339825S. Let's make sure line 41 and line 43. Is that what you said?
Yes, sir. That's exactly
okay.
What I said.
So you want to move the 5 on 44 to 3 and the 3 on 41 to 1. Is that correct?
That's right. Thank you.
All right. Is there a second? Second from the pro tem. Any discussion on the proposed amendment? All those in favor of the amendment, raise your hand. It is 5. All opposed? It is 5. Well, the chair votes no on the amendment. Amendment fails. Any other amendments from the committee? Leader Hatchett.
Yes, Mr. Chairman. I'd like to offer the amendment AM 332106, which was provided. Just a little background on this. There's a loophole in Georgia's insurance laws that basically allow an insurance company that provides a policy to a city to include a provision in there that states if the city didn't have insurance, if they weren't liable or wouldn't have to pay damages if they didn't have insurance, then we're not going to cover it. So basically it closes that loophole so that if a city does buy insurance, they are protected and the insurance company can't say, well, we're not going to provide insurance coverage for you. It's a loophole that was brought to my attention earlier, and I think it's in the best interest of taxpayers and cities to close this loophole so that they are confident when they buy insurance that the insurance will cover their damages.
All right, does everybody have the proposed amendment from Leader Hatchett? Is there a second? Do we have a second for the proposed amendment? Second from Leader Jones. Any discussion on the amendment? Senator Watson.
Can we hear from the author?
Yes, he already, well, go ahead and go away again.
Thank you. Knowing a little bit more explanation helped. You know, I could guarantee Floor Leader Hatchett I would work with you in the future on that, but that is outside the scope of anything that's been considered in this carefully considered bill, and I would ask the committee not to include that at this time, but I will work with you in 26 on that important issue. But it's different than everything that's been studied in depth in this, but it sounds like something that you care about that may have a real world effect, but it's just outside the scope of everything that's been analyzed this year so far.
Pro Tem, are you?
Just a question, Mr. Chairman, and Leader Hatchett and I talked about this offline, and I think I understand the loophole he's trying to close, and I like the idea, but I've expressed to him my concerns about the sentence that begins on line 25 that says, among other things, the duty to pay damages on behalf of a municipality must be determined under the policy of insurance without consideration of whether immunity would otherwise exist for those damages. And I'm afraid what would happen is you would have liability being visited at a time and place when immunity should attach solely because there was insurance coverage. And I think that's going to be chaotic for the determination of how does the city reconcile that, how does it determine its exposure under circumstances where the law gives it immunity protections, but language in an insurance contract somehow with this language excuses that or circumvents the immunity that the law otherwise provides. I think it would, I'm not sure that language is where we need to go with this.
Go ahead.
Additionally, I know a lot of state leaders are going to be studying insurance for the rest of 2025, and I think this is one thing to study in more depth, and I assure the floor leader we would do that if it doesn't pass. I would ask the committee to stick to the
Move
scope
forward.
to fix a problem that's urgent and on fire.
Any further discussion? You want to move forward with your amendment? All right, any further discussion on the amendment? All those in favor of the amendment, please raise your hand. It's 5. All opposed? 5. The chair will vote yes on the amendment. Amendment moves forward. Any further amendments? Mr. Walker,
Just
you have
permission.
an amendment to offer?
Just permission to make conforming changes. The amendment was crafted for a previous version of the bill. If I can just update the amendment to fit into the current substitute.
Any objection from the committee? Hearing none, that'll be added to the amendment. All right, no more lights are on. Back to the motion do pass by committee substitute as amended once. Leader Cowsert.
Just in nature of discussion, I think you may have just hit on something in your comment that the insurance industry is being studied by House Subcommittee. I'm very uncomfortable with us being 3 or 4 times the minimum limits required by our neighboring states. And in a year that we're passing tort reform, this is most definitely going the opposite direction, if you ask me. And I'm not comfortable with the bill in its current state, and would urge us to pump the brakes a little bit and let's think what we're doing before we go this extreme of a position. Just want to let you know that was a great idea of yours to convert this to go to a study committee, or just mold it in there and then y'all can smoke it over and feel what the right level of insurance ought to be.
Any further discussion from the committee? All right, all those in favor of the motion do pass by committee substitute as amended, raise your hand. 7 opposed. 3, motion carries. Who's carrying the bill in the Senate? Just let us know by the end of the day. Thank you.
Thank you, committee.
All right, we have just a few bills left. Let's keep rolling. House Bill 627, Representative Persinger. Come on up. Thanks for sticking with us.
Yes, sir. Thank you, Chairman, members of the committee.
We have LC 481566S, the version that passed the House.
That's
the
it.
floor is yours.
Thank you, sir. This bill passed this committee last year. It's a straightforward cleanup bill in the juvenile code. All we're doing is striking that line you see there, provided that such a deadly weapon is not a firearm, out of the Class A Designated Felony Act to make it match the Class B definition as well, so that we're getting parity in the 2 definitions, so there's no confusion there. That's the bill.
Could have said that 2 hours ago. That's
I know,
what
right?
you're thinking, right?
I was hoping.
Any questions from the committee? No one signed up to speak on the bill. What's the pleasure of the committee? Motion to pass from Leader Hatchett. Is there a second? Second from Senator Cowsert. All those in favor, please raise your hand. It is unanimous. Who's carrying the bill in the Senate?
I'll get back to you about this afternoon.
Okay. Thank you.
Thank you. Is that LC
6.
number or LC 481566S?
That was 627. All right. House Bill 304, Representative Yurda. Are you still with us? Come on up. We were working off of LC 3598S.
Yeah.
All right, the floor is yours.
Thank you, Mr. Chairman. Committee, I bring to you today House Bill 304. It's got actually 2 sections. Section 1, it actually creates a senior municipal court judge position. This position would be a former municipal court judge with 10 or more years experience wishing to become a senior municipal court judge would make application, which would be reviewed and acted upon by the president of the municipal court judges. Upon approval of this application, the judge would attain the position of senior municipal court judge status. The judge would be eligible to serve in our municipal courts as long as the judge continued to retained certification under OCGA 363227. The senior municipal court would continue to be a member of the Council of the Municipal Court Judges of Georgia. The bill does not guarantee a senior judge will be selected by a particular municipality. Any senior judge would be subject to the normal selection process. This makes no substantive changes to the operation of the municipal courts. The second part of the bill, you've previously heard statutorily creates the Georgia Municipal Courts Clerk Council. Currently, there are 389 municipal courts in Georgia. They're the largest class of courts in the state, from Atlanta, who holds courts multiple times a day, to very small cities that may hold court every other month. Despite the diversity in these municipalities, every municipal court has to follow the same laws and rules to make sure the court is run properly and respects the constitutional rights of everyone brought before the court. This will help to assist in standardizing the operation of the municipal courts and further bring professionalism and administration to the courts. This will also bring aid in creation of municipal court certification program that they're interested in bringing forth. This will bring an entity that respects the needs of the municipal courts in the state of Georgia. This will allow more training for the municipal court clerks, and this will allow them to better serve the public. The municipal court judges support this legislation, and I just ask for your favorable consideration.
All right, thank you, Chairman Yurda. Any questions from the committee? We do have 3 individuals signed up to speak in favor of the bill. No one speaking in opposition. Anybody want to add anything that signed up? Briefly, that somebody's wanting to make a motion, so. All right, what's the pleasure of the committee?
It's late.
Motion do pass. The hardest thing for lawyers, in particular for us, and politicians, learning when to be quiet, right? And so we struggle with that.
But as a judge, I've learned.
You know. Okay. Motion do pass, and there's a second from Senator Kennedy. All those in favor of the motion, raise your hand. Good work. Thank you all. You have your bill. I know y'all have worked for at least 2 years on this, if not 4 years.
Yes, we worked a while. Thank you.
All right, thank you. Thank you all for sticking with us. Who's carrying the bill in the Senate?
Let you know.
All right.
I'd be happy if you did it.
Why not? Sure. Okay, I'll carry it. Thank you. Appreciate you. Thank you. All right, we have one last bill. Chairman Smith is still hearing a Senate bill. We'd like for him to keep doing that. So if y'all are good, we're going to have Judge Land come up, and I'm going to assist with presenting this bill because we've worked a little bit. Well, he in particular has worked the last year on it, but I'm aware of it as well. House Bill 179. We're working off a committee substitute that is LC 481604S. And I will let Judge Land talk about the bill. The committee substitute does not include language that was added into the House that I believe Mr. Lindsay, as he's back here, is going to address, and I think he's going to make a case to put back in. The committee substitute does not have that in there. I'll let Judge Land present the bill, and then I'll address the changes directly.
Okay.
Thank you.
Thank you, Chairman Strickland, and thank you, members of the committee. This is a bill that we have worked on probably for the last, well, before I got involved in it, for probably the last 4 or 5 years. It's been floating around. I got asked to chair a committee about 15 months ago and have been working diligently on it since then. We have convened a committee that includes Superior Court judges, state court judges, probate judges, juvenile court judges, me as the Court of Appeals representative, and a Supreme Court Justice, Carla McMillan, to address the growing crisis created by the shortage of court reporters in Georgia and throughout the nation. And we've heard reports from judges all over the state of the problems that they have getting court reporters to come to court to do their official job, or finding court reporters to fill those roles. We have judges in South Georgia that have to get court reporters from out of state, We have judges, particularly in state courts, who simply cannot get court reporters, and they're handicapped in their ability to hold court as a result. So our bill that we came up with that is presented to you today seeks to alleviate that problem, mitigate that problem. It will not solve it entirely, but it will certainly help by allowing judges at their option to digitally record court proceedings and then have a court reporter, when needed, type up the transcript, prepare it, and certify it. In other words, it would, in certain proceedings at the judge's option, would allow court to proceed without a court reporter sitting there with the judge. We presented this to our committee. It unanimously passed our committee. It passed the Judicial Council Legislative Committee without objection. It passed the Judicial Council. I took it to the State Court Judges Conference at their annual conference. They were strongly in favor of it and urged me to continue on. I spoke with the Superior Court Judges Council's Executive Committee, answered all of their questions. They were good with it. So we've gotten tremendous support. Representative Smith presented this in the House. It did pass the House Judiciary Committee with one amendment that is not my issue at all. Our issue is only confined to allowing digital recording of proceedings in court. There was an amendment proposed, and I'll let them speak to it after I finish, by Ed Lindsay on behalf of some court reporters to make a change to OCGA 91130 dealing with depositions. That was not in any way, shape, or form my idea. It did not pertain to what I was trying to accomplish. But what I told Representative Smith and what I told the House committee, if y'all want that in there, I didn't see a harm in it. I just want my bill passed. So it got added, it got passed, and that bill unanimously passed the House. I take no issue one way or the other with that particular amendment to OCGA 91130. I know we have other court reporters here, represented by Terry Rogers, who's going to speak to you about why they don't want that amendment in there, and they want you to pass the substitute, which simply takes that amendment out. And my position is it really doesn't matter to me. I want the bill to be passed. My bill did not have this amendment in it. I don't think it relates to what I'm trying to accomplish. If this committee and the Senate ultimately passes the bill in the same form the House passed it, that's fine with me. If you take out that amendment and pass it as a substitute, that is also fine with me. We'll go back to the House, and I trust Representative Smith can get that passed in the House and we can get this done. This is a long-standing problem, and it really needs to be addressed now, and I'd hate to see this can kicked any further down the road. So that's my position on this bill. We appreciate your consideration.
Thank you, Judge. You do have questions. Chairman Cowser.
Thank you, Mr. Chairman. Judge, good to have you with us. I'm traumatized by this bill, and it's from personal experience. Clark County State Court, at least one of the two judges does not have a court reporter, at least one that'll come live. And so whenever we try matters in that court, she's on Zoom somewhere. And I know what's going to happen. Every court's going to go digital if they have the ability to, because of the problems you've described. It drives me crazy in the trial is she'll interrupt us in mid-question, say, please get the microphone, hold the microphone, because it is very difficult to have a digital recording. And so I've got to go make a closing argument holding the microphone in my hand, you know, instead of talking and pointing to charts or whatever, to appease this, you know, court reporter in the box on the wall. And I wonder what happens when, you know how many times you've had in your trials where you're like, could I get the court reporter to read that question back to me? How in the world do you do that if you just got a tape recorder going?
Those are great questions. Those are questions our committee thought about and considered, and there's several things in this bill that I think address that and help alleviate that concern. The first is, and I should have said this when I was introducing the bill to y'all, this does not apply across the board to every court proceeding. That's the first of all. There's an exemption in here for felony jury trials, so no felony jury trials will this be allowed in. There's an exception for evidentiary hearings in felony cases where witnesses are testifying, primarily for the concerns that you just stated, that in felony trials we don't want to run that risk at all. And then there's an exception across the board for civil or criminal cases. If the lawyers can provide a court reporter, then this will not be digitally recorded. The judge doesn't even have the option in that scenario. So in your civil case, if you can provide a court reporter, and you and your adversary can agree on how to split the cost, et cetera, then there will be no digital recording allowed. The court reporter will be the preference. Because as I've told people, I practiced law for 25 years. I presided in Superior Court for almost 5. I would always prefer a court reporter, always, without exception. But there are plenty of situations throughout the state where the judges do not have that option because they cannot get a court reporter. So the policy question is, do we just grind court to a halt because of those judges that can't get court reporters, or do we allow the judge in his or her discretion to employ this as an optional remedy for that, and to police the proceeding? Have people speaking into microphones. Have you, if you're really going to do a trial with this, have a microphone on your lapel. And if the judge supervising this who wants it can enforce that, then you're going to have a good transcript. If he or she doesn't want to do that, they shouldn't be using this. And I've heard from plenty of judges who said, I would never do this. That's fine. That's why it's optional. None of this is mandatory for the judge. And the lawyers have an out, particularly in the civil cases where you've got relationships with these court reporters. If you want to bring a court reporter to trial, you have the absolute right to do that under this bill, and there will be no digital takedown. What this is primarily designed to do is to give those judges in state court who are doing arraignments en masse, they're doing guilty pleas en masse. You've got a hearing where it's a lawyer like me sitting or standing at a table speaking into a microphone. It allows them to have court and to have those proceedings done. It's going to require oversight by the judges, and it's not perfect, but I think it is an excellent solution to help mitigate the problem we've got.
One follow-up, if I could. So can either lawyer demand a court reporter if they pay it, or do they both have to agree?
I think if they agree on the payment of it and the court reporter's willing to come, I think the way the bill's drafted, that would have priority over the digital takedown. So the judge could say, if y'all will provide a court reporter, or if you, Mr. Cowsert, will provide a court reporter, by all means, do so.
Would the cost for that court reporter be the same as the court?
That would be, I suppose,
that could be exorbitant if it's private. You know, what you pay a court reporter just for takedown if you don't get a transcript isn't much at all.
Yeah, I think if you're bringing your own court reporter, I think that'd be between the parties and the court reporter.
Thank you.
Any other questions from the committee? All right, thank you, Judge. Doug wanted to share ACCG is fully supportive of the bill. The underlying bill has no position on the proposed amendment, but this is a legislative priority for ACCG. I got that right? All right. All right, let's, thank you, Judge. We're going to have a couple other people speak on it. We'll start with Edward Lindsay. Is it Cutter? Did Mr. Lindsay write this on there? It looks like a doctor's handwriting.
Yeah.
Doctor of Law.
Yeah. I learned over the years. Try to hide. Mr. Chairman, members of the committee, my name is Edward Lindsay. I'm a partner in the law firm of Denton's, and I'm here representing today 4 different court reporter organizations, Esquire, Veritex, Magna, and U.S. Legal. Combined, they have several hundred court reporters working with them in the state of Georgia. And they came to us to represent them to try to deal with an issue that is of greater concern in the, for want of a better term, the legal court reporting marketplace. Because we have an antiquated statute in 9/11/30 that only refers to stenography in terms of depositions, even though the Board of Court Reporting and the state have moved beyond just stenographic court reporting, but various different forms of court reporting, voice, digital, and other forms of court reporting that have been approved by the Board of Court Reporting in the state of Georgia. And what we were simply trying to do was look for ways to get that updated. Our original, and to Judge Land's point, we originally were working with several members of the House Judiciary Committee to start a separate bill. But understandably, in the terms of legislative economy, they said, well, we've already got this other issue dealing with court reporting. And so we ask you to please see if you can do an amendment to that and see if that can be something that can be approved. And so we worked with several folks on this. This is not something that was done on the fly. This is not something that we simply brought to folks and said, take it or leave it. We worked very carefully with folks. And Judge Land, while he is accurate in saying he has no position in it, he was nevertheless very gracious with his time, and I do appreciate it, in that he did, as part of the process that we had with talking with various folks to try to come up with the proper language, did convene a group of folks that included members of the Board of Court Reporting, other court reporters, and myself to see if we could come up with language. The simplest language that we came up with was one. Now, I don't want to misstate it. They're not necessarily endorsing this, but the simplest, in order to do what we think needed to be done, was the language that's contained. And I'm looking at LC. If you could pull out LC 481561S, that should be in your.
Mr. Lindsay, they're bringing it now.
Oh,
I forgot to put it.
Copies.
Okay, when you started talking, I promised you yesterday to make your pitch for the amendment, I would put the original bill in the folders. I didn't do it. It's on me, so you've got it.
With all due respect, Mr. Chairman, I've been around the legislature for over 20 years. I know how it works for the last 2 weeks. So I bought extra copies.
So we'll have copies now. So y'all, what you're looking at, to be clear, this is the version that passed the House.
Yeah.
And the change he's asking for, I removed with a committee substitute today. And so you want to point them to the lines so they can see that.
Yeah, if you would, look at, once everyone has it, look at line 128, section 1-2. That's the language that was added after an intense amount of discussions with the various different entities. And what it simply does is that it brings Georgia's law regarding takedowns and depositions up to the 21st century. And allows for the fact that the Board of Court Reporting is the proper entity to determine the proper methods of court reporting in the state, and says simply that must be recorded by any means permitted by the court reporting of the the Board of Court Reporting of Judicial Council, this is well within their province of what they're supposed to be doing in terms of certifying court reporters to be able to take depositions. Like I said, we work very hard to vet this and to determine whether or not there's some unintended consequence out there, or whether or not this is trying to give some type of leg up for one group versus another. And the general consensus has been that it doesn't, that it simply just recognizes that we have multiple ways in which we can do takedowns with court reporters present, and we're simply going to allow that any means that has been permitted by the Board of Court Reporting, the depositions can be taken in person. As Senator Calvert has expressed his concerns, it's the same concern that I have. I've been practicing law for 40 years, and I've had the same concerns. And more than once, I've had to ask the court reporter to please read back a certain question or read back a certain answer. And that's exactly what we're looking for to do here today. Like I said, I want to emphasize that this wasn't something that was done fly of the night. That this was, matter of fact, there were 2 hearings that were done in the House Judiciary Committee, in which we were sent back to try to work out the appropriate language. At the end of the day, we came forward with this language, and I, once again, while he certainly didn't endorse it, I do appreciate Judge Land willing to sort of bring the people together to at least listen to the different concerns. I appreciate the representatives from the Board of Court Reporting of the Judicial Council to be there. Matter of fact, some of this language was, Edward, if this is what you want to do, this probably would be the best way to do it, and that's why we have it in here. With that in mind, like I said, We worked very hard on this in the House. We worked very hard on this particular language to try to make sure that all we're trying to do is take care of every court reporter operating in the state of Georgia who's been properly certified, be able to do their job in terms of taking depositions. That's all it does. It takes care of the folks who work through our respective services. It takes care of the independent folks as well in the various ways in which they do the takedowns. And I think that is a point that's very careful, that needs to be understood. In regards to Judge Land's point, which is, they want to get their bill passed, understandably so. And we have no objection to their bill. This is also the simplest path forward if you would simply just pass out LC 481561S. Because by doing so, assuming that it passes the Senate, it's done. It goes to the governors for signature. If this language comes out, it then goes through the added complication of going back and forth between the House and the Senate and the closing days of the General Assembly. And folks, we've all been there in terms of getting something done. So in terms of getting what Judge Land has worked very hard to get done, I would submit to him and submit to you that the easiest pathway would be to pass this bill as it was passed out of the House. And it's also a particular amendment that's been well vetted. And with that, I would ask for you to listen to my client, Adam Cutter, who can sort of explain to you why this is so important within the marketplace.
Absolutely.
So the posture we're in is we have a substitute that was noticed by the chair, which you have in front of you. They're wanting to make a pitch for a proposed amendment that would go back to, in essence, would go back to the House version. And so I wanted to give them a chance to at least let him make his pitch, and you can decide whether you want to offer that amendment. But if you can try to keep it to 2 minutes.
Yeah.
Yep.
Mr. Chairman, members of the committee, thank you. My name is Adam Cutter. I work for Veritex Legal Solutions, started in court reporting back in 2009 with Tiffany Alley and Associates, and have been seeing a lot of change. Been responsible for the Southeast, including Georgia. And what we've seen over that time is as the shortage, as we've all talked about, as that has become more exasperated, the use of other capture methods has been important, from stenographic to digital as well as voice. And so as Mr. Lindsay mentioned, the Court Reporting Board has acknowledged that there's certification ways to do that. And so simply the language that refines it to stenographic just causes confusion within the marketplace, right? And when a digital reporter or a voice reporter shows up and somebody says, well, is this stenographic? There's confusion around that when there's certification around the others. So we believe that by making this slight change, it will remove much of that confusion.
All right, and I'll tell you in our discussions getting prepared for the hearings, my concern was when I looked at the bill, I was getting some different responses from other court reporters, and it felt like while the original bill dealt with, from Judicial Council, courtrooms, what was happening in the courtrooms, this expanded it to depositions. And while you may be correct, it seemed like we were getting into a deeper conversation about how we do court reporting, and it was my opinion that it was going to potentially jeopardize the bill, and so that was why I offered the substitute, but I understand your position on it. Any questions for Mr. Lindsay or Mr. Cutter? Senator Cowser.
Y'all got to help me find the place in this bill where it says council have to consent to it, or can somewhere.
That goes
back to Judge Land.
I'm reading it fast as I can. Yes,
Let's
sir.
come back to that. Let's see if any questions for them about their proposed amendment. Senator Watson.
Just to clarify that if we pass it as passed by the House, it passes the Senate, doesn't have to go back for an agree, it goes straight to the governors if it passes for signature.
Correct. That's correct.
And we're at the very end of the session, just, I know how things get hung up. Okay, gotcha, thank you.
All right, any other questions for Mr. Lindsay or Mr. Cutter? All right, let's do this on the same subject. Mr. Rogers, Ms. Pope, do y'all want to come up and address that? And we'll go back to Mr. Land to close it out. All right, the floor is yours.
All right, Mr. Chairman, members of the Judiciary.
My name is Jennifer Pope. I'm not going to say much, not going to spend a lot of time here. I debated a lot of this in the House. I think one of the longest people around been working on this legislation. It's been about 6 years for me. I've seen a lot of different iterations of this. I have to say I've had meetings with Judge Land, Justice Peterson, Judicial Council. The Board of Court Reporting, first off, has never looked at this bill, so I think that's very important. They are not for this bill or against this bill. I'm actually a member of the Board of Court Reporting, so I would know that. I would urge you to pass a committee substitute that Chairman Strickland has proposed to you guys. This was always about courtroom, about digital recording systems in the courtroom. We need to update the Court Reporting Act. There are about 24 statutes in there. I have never once heard of any issues pointing back to 9/11/30 where it says stenographic. Well, you're not a court reporter because 9/11/30 says stenographic. Stenographic means. So I know there needs to be some updating to the Court Reporting Act, modernization of it. I think there needs to be more to this other than any means permitted. That is clear by the Board of Court Reporting. We've got 3 methods, well, really 4 if you're counting pen. I think there's still 1 person who does pen in South Georgia. So you have pen, you've got machine writing, voice writing, and now digital court reporters. They are all 4 considered certified court reporters. Now, if you look at the definitions, it says that. In the definitions, court reporting, those methods. It doesn't say digital court reporters, but it talks about any other means permitted by the Board of Court Reporting. So that is already in the language. Again, I just urge you to pass the committee substitute. Are there any questions?
All right, any questions from the committee? All right, thank you.
Mr. Chairman.
Mr. Rogers?
Yeah, just one quick thing that I want to offer. The original bill that was sent back to the House did not have this amendment in it. The amendment was offered at that time. That bill had been crafted in conjunction with the court reporters and with the Judicial Council. And that was the bill that you had. The amendment, we agreed to the amendment because of a time factor. We were talking about time factors earlier. You were right before day 30. We agreed to the amendment and very specifically said that we would work it through the committee process and bring it to the Senate because we did not like the amendment, but we did not want to hold up Judge Land's bill. At that point, that is when you took it and we had the conversations. We had some few conversations. You looked at it and you had your concerns. We think the substitute is a great way to handle the situation and that we would encourage you favorably voting for the substitute.
All right, any questions from the committee? All right, what's the pleasure of the committee? Motion to pass. Second. Is it by committee substitute? LC 481604S.
Mr. Chairman, I'd like to go back to the bill as it was passed out of House Committee, which will be.
The posture we're in is the notice substitute is the one I named. You need a motion to pass for that, and then you could offer as an amendment the paragraph that Mr. Lindsay presented from the original bill.
All right.
So you want to offer a motion to pass by committee substitute. Is there a second? Second from Senator Kennedy. Do you have an amendment you want to offer?
Yes, the amendment that is outlined in what he handed out, lines 128 through I guess that goes down to 161.
All right, so the language you would have, is that right, Mr. Lindsay?
It would be, the language would be lines 128 to line 151. In LC 415. What are those numbers line 128.
Go to the mic. Let Mr. Lindsay sit there for a minute.
Like musical chairs. The language reading off of LC 481561S would be from lines 128 to 151. That would mirror and therefore.
And this was the way it was passed out of the House?
Yes. Yes, so that if this was in there, it passes the Senate, we're done.
I'm not sure if that's, I think it has to go back either way at this posture based on me having the committee substitute.
Could the committee simply just pass the bill as passed by the House?
That's not the substitute on the agenda.
Okay,
so no, you
understand.
can't.
The chairman has the authority to change the agenda at his discretion.
Right. And I'm not going to do it. So we'll have this substitute is the one that's offered, and you instead would offer your amendment to change the substitute. So either way, it's got to go back to the House for an agree.
But since there's no difference in the language, I believe that would leave that to legislature.
It'd be up to and I could be wrong. We don't have, well, we'll figure it out. We'll figure it out.
I would submit that if you don't change any language at all, regardless of the number, that it doesn't. But I'll leave that to the Legislative Council.
Pro Tem?
I'm confused, since maybe I'm not the only one. So what the chairman has presented or offered us today is not LC 481561S, which is what did come from the House?
So what is offered for you today, that's correct, is LC 481604S. That was the committee substitute.
And how is that different from?
It removes the deposition piece that was added in the House that Mr. Lindsay spoke on.
Okay.
That Ms. Pope spoke in opposition of. That was the piece that Ms.
If it helps, yeah, I think the intent was.
You want to come up here?
If it helps the committee, the substitute, as I understand it, simply would remove lines 128 through 151 from what passed the House.
It would go back to it's where it gets confused. The original bill as presented in the House, but not as passed the House. When the House added the amendment.
Okay. So to be clear, per the chairman's prerogative, it is the chairman's suggestion that we vote on the substitute offered today, which is what came from the House, but striking the portion regarding the updated stenographer language.
Yeah, and to be candid again, my issue was when we were working on the bill, there was dispute amongst court reporters, as we saw here today, about that additional language. No one was disputing the original underlying bill that Judge Land's committee brought. And so as chairman, my thought was this late in the game, we saved the discussion about the court reporter battle for another day, which is why I suggest the committee substitute. I don't necessarily have opposition to what Mr. Lindsay's offering. As fairness to him, I told him to come make his pitch to the committee. Maybe that created more confusion, but I was trying to be fair because I made that call myself and just looking at the players involved.
Thank you for that explanation. So what would be the number, what would be the
So you made the committee, the motion that I had y'all make was the correct committee substitute that I offered.
Okay.
The question would be whether to offer the amendment. The amendment would be going back and adding that language back in.
Okay.
And so let me go back to, do you want to offer the amendment, Chairman Watson?
No, I don't think you do. I don't think you do.
Let me turn your mic on.
Having been here 15 years, I think that whoever takes responsibility for the bill, if they do not take responsibility and go back and get an agree, it's not going to be done this year. And that's my concern as just a plain old senator. And
He's not in the room. Chairman Smith, this is his bill. We talked about advance. He doesn't have a particular position. It was added in committee on him.
I understand.
He's okay with this substitute, but he also doesn't have a particular position on the potential amendment. So I think you have a commitment from him.
I voiced my concern that it will not pass as it is, as you have suggested, and I'll withdraw my amendment.
All right, and you may end up being right.
We'll see.
All right, so back to the motion, do pass by committee substitute. All those in favor, raise your hand. It is unanimous. Who's carrying the bill? Well, I guess I'm carrying it. Okay. It'll follow me. I'm carrying the bill.
We'll take volunteers.
I'll carry it and see if we can make sure we get it done. All right. Thank you.
Appreciate your time.
With that, we are adjourned. Thank you.